And Mr. Moulton, you are still counsel of record for Mr. Clarke?
Yes, sir.
All right, and you're Mr. Clarke? Hey, Mr. Clarke. And then Mr. Pastel, you are counsel of record for Greystone, and sitting with you is?
Ryan Sharp. No, go ahead. You introduce yourself.
Good morning, Your Honor. Ryan Sharp, I'm associate with law firm.
Great. Welcome, Ms. Sharp.
Thank you, sir.
Thanks for being here.
We're trying to get some trial experience for associates. It's hard to do these days.
Well, we're starting it back up. We start next week. Judge Taylor in state court will be debuting our virtual jury selection, but in-person trial. So on the 13th, he'll pick a jury in his courtroom. I think the lawyers will be there as well. The potential jurors will be on a screen, but they'll come in the very next day for the trial to start. So the 6 or 12 they'll actually be in the gallery of his courtroom, and I'm a couple weeks after that. So I'll have a actual in-person civil jury trial here. We just have to do jury selection remotely because that's the one step where we haven't figured out the real estate for doing jury selection. All right. Well, before we dive into the substance of the matter, Mr. Moulton, you may testify as to attorney's fees. Mr. Clarke will be testifying as plaintiff about all the relief you're seeking. Mr. Pastel, as I understand, you might testify as to attorney's fees. And then I had a note here that someone named Beth Harper might be testifying. Is that Beth Rodriguez?
Yes, that is. And my testimony may go slightly beyond attorney's fees.
You can go wherever it goes, but you don't need to leave. You're testifying. I'm just addressing Mr. Moulton's observation that we may need to invoke a rule. Ms. Jackson is not someone you plan on calling as a witness?
No, I do not, Your Honor.
Okay. Ms. Jackson, you're welcome to listen in. You also can watch and hear everything on the YouTube feed, but not a problem having you on the Zoom call if this is the way you want to observe what's going on. And then is it Ms. Harper or Ms. Rodriguez? I don't want to call her the wrong name.
She's trying to talk, but I've always called her Beth Harper as long as I know her.
All right. Well, if she testifies, when she testifies, her name will get on the record.
There you go.
What is her connection? If we were doing an in-person trial and everyone needed to be here, would she be at counsel table with you?
She would be.
Okay.
She's on the board of directors, been on the board of directors for many years.
Okay. So, Mr. Moulton, given the representation that Ms. Jackson is not going to testify, so she could be sitting here in court anyway, and Mr. Pastel would, as basically the representative of the defendant, would have Ms. Harper Rodriguez sitting at counsel table as the representative for the defendant. It doesn't seem like she needs to be excluded, but I'm happy to hear you out if you think she shouldn't be.
No, I concur with that.
Okay, got it. And I'll let you all know if anyone shows up in the waiting room before we let them in who they are, and they may need to just watch on YouTube, which they're free to do. Okay, so my recollection of the matter is that Mr. Clarke was, the news to me is he no longer is, but he was a homeowner at Greystone, and he had leased his house out. That lease was not executed pursuant to the homeowners association covenants or whatever we're going to call the rules. That led to some fines. There were additional concerns about a stump in the yard. I think it was represented that the stump issue had been solved. That doesn't mean there aren't still fines out there, but that the stump is gone. There's now something that is new to me, at least I'm not remembering it, about white stones. But the big issue that confronted us earlier was Mr. Clarke's continuing desire to lease the property because he doesn't live there. It's for him, effectively, it was a rental property. And the community association was refusing to consider his properly submitted application for approval to lease the property because he hadn't paid the fines, maybe not for the stump, but certainly the fines that accrued for having, in the community association's eyes, improperly leased his house before. And until that fine was paid, the association weren't going to consider any new lease applications. I addressed that in an order. That part is moot now because Mr. Clarke doesn't own it anymore to lease. And as I understand it, what we're working through is who owes what for these alleged violations. I think Mr. Clarke is seeking recompense for having been unable to lease it, and the community association is seeking to have what it views as properly assessed fines for stump, for improper lease, and maybe for some white rocks or lack of white rocks. But that these assessments need to be paid, and then everyone wants attorney's fees. So that's sort of my overview of where I think we are. I want to give both you, Mr. Moulton, and you, Mr. Pastel, a chance to say, no, here's where we really are, and then let's get into the evidence. Okay? I'll start with you, Mr. Moulton.
Thank you, Judge. So that's all accurate and you've laid out, so I'll try not to belabor this, but Mr. Clarke, who in some of the records you might see his name was Tarlew, changed his name after he bought the house to Leo Alexander Clarke.
But his last name was Tarlew, or his first name was Tarlew?
It was Leo Tarlew.
Okay.
So, but I just try to avoid a little confusion. If you see that name, it's the same person. He bought the house in 2011. He lived there until 2018. When he bought a different house, he had this tenant move in October of 2018. It was supposed to run through October of 2019. But the tenant stopped paying rent in May of 2019, and Mr. Clarke filed an eviction, which was granted in July of 2019. So he received about 10 months of rent. Actually, maybe the evidence would be even less than that, but some rent was paid. Around the time that he filed the eviction, it was actually May 22nd, if I understand the correspondence, was the first time the association notified him that he was in violation of this leasing provision. So October of 2018, he leases it. It's May 22nd that he gets this notice. And then June 4th, 12 days later, is when he actually filed the eviction. So he didn't actually collect any rent at all after he was notified about the leasing issue. He met with the board. He'll testify he met with Melanie Jackson, who was the leasing coordinator. Tried to work it out, could not work it out. In August, the association entered a fine of $15,500 on his account. By then, the tenant was gone. He tried to get permission to lease it again, was told you can't until you pay this. There were some meetings in October and November that at least one took place, one was canceled. And then finally in December, he came to my office. I wrote the board a letter and proposed to pay the $1,000 fee to file a new application plus a $250 fine. Explained his side of the situation. That was apparently not acceptable. He got another letter about fines in January, which I responded to and was told we needed to deal with Mr. Pastel because now that we had a lawyer, we had to deal with the board's lawyer. And so, we sort of got to the point where he felt like he had no choice. He couldn't use the property. He didn't feel like he could sell it because he was going to have to pay this enormous fine. And so I filed the lawsuit in hopes that, it's one of these things where you just feel like, I can't believe we've gotten to this Alice in Wonderland place, but this is where we got. I thought the lawsuit might shake this loose. It did not. So we filed the TRO, which you sort of granted in part, denied in part. My client was unable to pay the money into the registry of the court as you laid out in your order. I think you wanted half the money basically paid in. And so in January, he sold the property. When he sold it, the closing attorney got with the homeowners association and got a payoff letter from the homeowners association for essentially to transfer good title to this house. It was $26,000. I've got the exact number. Mr. Alexander will testify. It was over $26,000. It was taken from Mr. Clarke, proceeds in order to clear up this debt. So, as you know, 15.5 of that was the leasing fines. There was about 1,000, 1,500 perhaps on the stump. The balance of that, or a good deal of that, was attorney's fees.
So was I making something up about White Rocks?
No, there was a $100 fine for White Rocks.
Oh, so it's $100.
Yeah, that
Okay.
was around. He had put he had a surround on the mailbox of some pavers. Inside the pavers, he had White Rocks around the actual post. That was considered a violation of the covenants. We would not be here over White Rocks, and we would not be here over this tree stump. We are here really because of this $15,000 fine that I think you're going to find is not enforceable because the bylaws state that.
Well, I don't want you to make your argument right now. You'll get a chance to do that. I just wanted to have you orient me from plaintiff's perspective as to why we're here and make sure if I was missing something generically, factually. Obviously, the facts will come through testimony, but I was just wanted to let you know what I thought we were working through today.
That is what I think we're working through. We believe our attorney's fees should be granted because we believe that Greystone has been stubbornly litigious and unreasonable in this case and has caused all of this. There is a point I think that you aren't aware of that I wasn't aware of till this morning, and I think I should address it now. Mr. Pastel sent me exhibits 31, 32, and 33 at 8 o'clock this morning, which were a payoff of a mortgage from 2018 and a copy of my motion for TRO. Part of that motion recited that some of the distress that Mr. Clarke was suffering was that he was having to pay a mortgage on this property, and he intended to use the rent to pay the mortgage. And you actually mentioned that in your order. That apparently was not true. There was no mortgage on the rental house.
So Mr. Clarke told you that, but you have learned, or Mr. Clarke didn't tell you that, or where did that? I didn't make that up.
No. It's in my motion.
Okay.
I understood when I filed the motion that this house had a mortgage on it. It was he will testify about it. It was not an intentional attempt to deceive anyone. I think what happened was he told me he was having trouble paying his mortgage. I assumed, which is always the last thing you want to do, that he meant the mortgage on the rental house, but he meant the mortgage on the house that he was currently living in. And English is his second language. Not an excuse, but I think that was potentially part of the issue, is that I believed there was a mortgage on this rental house. I don't think it makes any difference in the legal analysis necessarily, but I believe that's part of the defendant's argument here today, and I thought I should address it now.
Okay.
Thank you, Judge.
You bet. Mr. Pastel, I mean, it's sort of quasi-opening statement. We're a little free-form today because it's a bench trial, but mostly I just want you to, if there are pieces of this puzzle that you expect are going to come out through testimony that I'm missing when I give you my overview of where I think we are, just let me know, and then let's get into the evidence.
How about this? I promise to keep it 15 minutes or under.
Under would be great.
Okay. I did prepare really just a demonstrative timeline. If people want to take notes on it, it might be easy that way.
Okay.
Can I slide it?
Yeah, no, that'd be great. You can come on up. Thank you, sir.
I did want to, before I get into my prepared remarks that I'll try to cut short, I did want to correct a couple things you just said this morning.
Okay.
You suggested that during this interim, after the eviction of this tenant, and while he was waiting, that he had properly submitted an application to the association. That, as you will find, is not correct. He did not. And there's even going to be disputed about whether or not the association would consider it. We were trying to work things out with them, and that doesn't mean we won't consider anything. Okay, so that's completely different. So with that in mind, I mean, as your Honor knows, we filed the counterclaim for payment of the fines. We also included a count for injunctive relief and self-help because of the landscaping issues. And like opposing counsel, I'm just going to skip the $100 White Rock fine, right? But the stump is at issue.
Well, when you say it's at issue, there's a fine that's at issue. Is the stump still there? I thought
the stump is gone, Your Honor. That got removed.
Okay.
But for some reason, while he removed the stump, he still just left it like that. He didn't have to put another tree there, or he didn't.
We can work through it. I just so I thought it had been represented that there was a complaint about a stump, and the stump was gone before I needed to rule on the stump.
Right. Well, that's right, because at that time the stump was still there.
Sure.
Right. And that's correct.
Okay.
And so, okay. But now, because of the sale of the house and the voluntary payment of all this stuff, right, all our counterclaim is gone except for the attorney's fees under the declaration in 13-611. Okay? Now, as your order points out, your TRO order, the association, the whole community passed a leasing provision, back in 2010, right? And it contains no less than a dozen condition preceding. I think Your Honor noted some of them in your TRO, but you've got to give advance notice to the board to rent, your proposed lease, the contact information for the tenant. You got to give where you're going to be living off-site so the association will contact you. It even has a third-party screening process for the tenant. That you got to go get a financial credit score and employment for the tenant you're going to put in there. Right? You have to attach the leasing provision on the back. There's the $1,000 administrative fee for here. And then the tenant and the owner must both meet with the board so everybody knows what's going on in this community. It's not taken lightly. And finally, the last two is, of course, you can't be in violation of the declaration. That's one thing. And you can't be delinquent to the association. That's another. They're not necessarily, you could be in violation and not owe any money and you still can't lease. I just want to make sure that's
like the timeline you've provided. Allegedly, Mr. Clarke was in violation and given notice of that in January of last year, but there were no fines assessed until the end of April. So
right.
An effort to lease in February of 2020 could have been rejected if all the other steps had been pursued because there was a violation, but at least as far as the trunk went, there were no arrearages.
Correct.
Okay.
Correct. Now, Mr. Clarke doesn't contest that he didn't do any of this stuff for his first thing. And as we heard, he had to evict his tenant over that. Then we had this injunction hearing, right? And Your Honor put a lot of conditions on it. You had to pay up everything but the leasing, fines, remove the stump that was put in there, and put $5,000 into the court registry. And as you noted, a big portion of your order and balancing act was the mortgage out there. And I'm not trying to, put impropriety on anybody. I, myself have made mistakes.
Sure.
So
But the fact is there was no mortgage on
Right.
the Greystone property.
that's right. That's right. So here's the important part. And this, at the closing or prior to closing, Mr. Clarke was fully aware that of the leasing fines for $15,500. I mean, that's what the lawsuit was about. Fully aware the stump fines were $3,900. That's, was included in my counterclaim, right? And they had discovery on that. The white rock for $100, who knows, right? And then that my legal fees will go over, that they have been incurred, right? So those were all well known when he went to closing. So just on Tuesday, 3 days ago, Mr. Clarke amended his complaint to try to circumvent the voluntary payment statute. Now that's section 13.113 of the code. I have a copy if you would like it.
Okay.
Would you like a copy of it? Yeah. It's fairly short. I don't know if you've come across it in any of your hearings and stuff. All right. And the amended complaint highlights, essentially reflects that highlighted portion that they're trying to get around on having, because they paid everything at closing, right? And now they're trying to claim, as he put in his second amended complaint a couple of days ago, that they paid it because of, quote, an urgent and immediate necessity for the sale of the property to release the equity in the property from detention and to prevent the seizure of the equity of the property. But, here's what the facts are going to show. As far as releasing the equity, Mr. Clarke could have asked to put the disputed money into the court registry. Your Honor already had kind of one set up in the TRO, but he didn't do that. Mr. Clarke could have asked to have the disputed money.
You make an argument, which I want you to say.
Well, the facts are going to show that he did.
But I understand that. But you can share that stuff later.
Right.
But just what you're suggesting, because you're clearly going to argue it later, I want to make sure I follow.
Right.
You are suggesting that Mr. Clarke at his closing should have said, I recognize that there's a lien that needs to be paid off on the property for this transaction to be completed. I'm going to pay it, but that amount that I pay, I want to go into the registry of the court.
He could have done that. That would have
Would the
done it.
closing have happened?
Well, first of all, I advised Mr. Moulton 10 days before the closing that they were doing a closing letter. I mean, this is no surprise of what happens at closing. Everybody gets their documents before.
Sure.
We did a closing letter reflecting this issue on here. So if the money was in the court registry, I don't know why they wouldn't have been able to close, right?
I don't know. If I'm the buyer, I might say, I'm not comfortable buying this. There's something going in the registry. I don't want a lien. It's not satisfied.
Who knows? But also, as your Honor knows, the POA statute says you can foreclose in the manner of a construction lien. Everybody bonds off construction liens left and right. He could have done that. He didn't do that. He could have asked me to escrow the money or worked with an escrow on it. That never happened. Significantly, he could have got a mortgage, Your Honor, or a HELOC, a home equity loan mortgage. Right? The facts are going to show he didn't do any of that. And as for a seizure of the property, that was nowhere in the horizon. Right? Before that could happen, Your Honor would have had to issue a judgment of foreclosure. I would have then had to convert that to a FIFE. I then would have had to give a sheriff's office a complete title report to their attorney. The sheriff's office would have served Mr. Clarke with 2 notices, and they have to advertise the foreclosure for a month. Simply, any foreclosure action, and we weren't even set for trial, was probably a year off before you're on the courthouse steps. Let me address the lost rent for a moment here. And this is some of the reason I have the calendar out here. He's claiming lost rent from May. I didn't even put that on there. Where is he claiming lost rent? No, excuse me. He's claiming lost rent from August of 2019. You might need to handwrite that in. Till he sold the house. What's interesting about that is he's the one that evicted his tenant in May, or July, excuse me, but yet he wants us to pay, the lease you'll see was for a year until October. So he wants us to pay him back for his lost rent because he evicted his tenant for August, September, and October of 2019. The first 3 months. That's not right. He's the one that evicted. He's the one that didn't follow. If he had followed.
But isn't, again, because we're getting into argument now, this is sort of hard for me to process. Isn't the response, no, I'm not asking the homeowners association to make me whole for a bad tenant because, this is plaintiff's theory, because you wouldn't let me release it, I couldn't collect rent in August, September, October of 2019. I was ready to release it. And you all were preventing that because XYZ will hear about it.
Right.
But I don't read it to say meaning Greystone needs to make me whole because I had a deadbeat tenant. Right. Just that I couldn't release it after I got rid of that tenant. And Mr. Clarke's eating whatever he lost because it sounds like that tenant actually lived there for a few months without paying rent. It was not a request for rent from January of 2019.
Right. And then, as Your Honor notes in your injunction order, the leasing provision calls for a $250 initial fine. The evidence is going to show that was never paid throughout it, or that $1,000 administrative fee. And then, again, regardless, actually, even before June 20th, January 20th of 2020 with the trunk violation. And the tree was already in violation before then, but formally in violation by that date. And that's continued through even the closing letter has the violation about just, you removed the stump and you left the ring and the mulch in there in the middle of your yard. Really? So that's not.
I don't know what the regulations are. It may be that people are free to build mulch rings throughout their yard. They just can't have a stump.
Well, the evidence will show they're not.
Okay.
Right on that one. So, Your Honor, and I put several case law I forwarded to Monica. I forget her last name right now, but
Nice.
no, right on the voluntary payment issue there that we'll go on over at closing.
Okay. All right. Well, I appreciate both of you orienting me to where we've gotten since we were last together. Mr. Moulton, why don't you call your first witness?
Mr. Clarke.
All right, Mr. Clarke, if you come on up to the witness stand here, you'll get sworn in.
Raise your right hand. Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth? To the state and study that of the court.
So I need you to talk in the microphone, put the mask over your nose. Great. And if you pull the microphone on down and then press the button on there, there's a red light. If you tap, there you go. It's green now?
Yes.
Excellent. Okay.
Judge, on the exhibits, I believe we have a agreed upon set of exhibits that, do you have those on your screen?
I can get them on my screen. I just don't pull them up until I know that it's okay for me to look at them.
I'll just say right now, as far as I'm concerned, all the exhibits, I don't have any objection to. Obviously his attorney's fees, I don't want that as a concession he's owed, but
No.
I don't have any objection to the admissibility of any of it.
And same in the other direction?
Yes, Judge. I think they're
34, I think, and we did not duplicate any, Your Honor. We just kept it all in a
Great.
number.
So what I'll do is take as stipulated the admissibility of plaintiff's exhibits as well as defense exhibits. I appreciate that there may be argument about the nature and extent of attorney's fees, but documents showing what they are admitted for our consideration. So let me just get to that place
Just,
in here.
so you know, Your Honor, Exhibit 7 doesn't exist.
Yeah.
I heard there's no Exhibit 7.
That's true.
Okay, so I'm now in the directory plaintiff's exhibits. All right. And what works best, if you don't mind, both counsel, if you've got all the exhibits, put them all in front of Mr. Clarke so that you don't have to go back and forth, and you're welcome to stay seated. You're welcome to be at the podium. I'm fine with either, but we do want to minimize the moving around the courtroom. So if you've got a universe of exhibits that you expect to cover with a witness, get them on up there in one fell swoop.
He's got the only ones he doesn't have are the recent ones from this morning and the actual covenants because they're so voluminous.
Okay.
But, Mr. Clarke, what do you do for a living?
I drive truck,
All right. And how old are you?
38 years old.
38.
38.
And are you married?
Sure.
Is this your wife here in the courtroom?
Sure.
Or what is her name?
Charlene Clarke.
Okay. Now, you purchased this house in Greystone in 2011, is that right?
Yes, sir.
And you look at Plaintiff's Exhibit 1 there on the top, is that the deed where you bought the house?
Yes.
Okay, and it refers to Alexander Tarlew. Was that your name at the time you bought the house?
Yes.
But you went to court and changed your name to Leo Alexander Clarke after this, correct? Okay. And you resided in this house until, and I don't want to lead him, but also I'm mindful of
Go
time.
ahead. Right.
Until around July of 2018.
Yes.
So about 7 years you lived there.
Yes.
And then you purchased another house is it in Lithonia also?
Yeah.
Okay. But you kept this house
Yes.
in Greystone.
Yes.
And it's 1136 Old Greystone Drive, right?
Yes.
And you wanted to rent the house, is that right?
Yes.
So if you see Plaintiff's Exhibit 2 there, you see that?
Yes.
Is that the lease that you signed?
Yes.
And your tenant was, I think his name was Iglesias,
Yes.
Jose Iglesias. And that was started on October 9th, 2018.
Yes.
And it was for a year, is that right?
Yeah.
Now, you knew there were covenants in the neighborhood, right?
Yes.
Did you know that one of the covenants was that you couldn't do this? You couldn't lease your house?
No.
Okay. So you didn't make any effort to get permission to sign this lease or have Mr. Iglesias live there, did you? Okay.
Mr. Clarke, you say you knew there were covenants. Did you ever take the time to read the covenants before this litigation?
So,
Let me show him. I'm going to show him number 20. Show you what I marked Plaintiff's Exhibit 20. And I'll just represent to you that as a copy of the original covenants for the neighborhood. The judge is asking you if you ever read those before.
No.
Okay, before you made this lease. Have you ever looked at those? Is that a no? Okay. We can leave those in there. Okay, so did the tenant pay the rent?
yeah, for some time, yes.
And how much was the rent?
$1,550.
Is the microphone? Maybe we could get it.
It's on. He needs to move closer to it. No, it doesn't, but he can. His chair, if he pulls hard, it doesn't have wheels, so he doesn't roll off, but it's movable.
I know it's been a couple of years, but do you remember when he stopped paying rent?
I think he stopped paying me February, March, April, May. I think May.
So
You gotta
that,
speak louder,
I
Mr.
think
Clark.
start paying me either in May, I think, March, I think.
2019.
Yeah, I think so.
So we paid October, November, December, January, February, March, April,
Yeah,
and then he seems like he stopped. Is that right?
yeah, I think so, yeah.
And this is towards the back of the packet. I'll show it to you. Exhibit 28. Is that the eviction that you filed
Yes,
in the DeKalb County's magistrate court?
yes,
And this was signed June the 4th.
yeah,
And you actually had a management company that was helping you with the tenant,
yes,
and that's who actually filed this.
Yeah.
And at the time this was filed in June, $3,100 was owed.
yes,
So it looks like you hadn't paid June, May, or June. That would be about 2 months rent, right?
yes,
And then the court granted the eviction in July,
yes.
the next month. And did he actually leave in July?
I think he left before July, I think.
Okay. Sometime in there, he moved out after he got served with that. Okay. Now, in May, a month before that, let's skip exhibit 3 for a minute. Exhibit 4. Do you remember receiving exhibit 4, Mr. Clark?
Yes,
This is an email from the association,
yes,
and this is telling you that they need information about your tenant and that you haven't abided by the leasing requirements, et cetera. Is that right?
yes.
You tell me, is this the first you knew of these leasing requirements, or do you remember any prior communication about this?
This is the first.
Okay. And this tells you to contact Melanie Jackson.
Yes,
And did you do that?
yes.
All right. Tell the court what you did in response to getting plaintiff's exhibit 4.
Well, Beth Harbor had written me this email. I received this email from Beth Harbor. And I was on my way. I think I was going to Berlin, to Germany. So she said in that email, if I can come on down to meet, they were going to be a meeting. I should come and meet Melanie Jackson, I think. And then I went there that day. The day they set up that appointment, I showed up there and I met Melanie Jackson there.
Let me stop you. How long after you got this email did you go and meet with Ms. Jackson?
When I got this email, I think it was, I went there, I think on the 26th, the very day that is in the email that I was supposed to meet Melanie Jackson. That very day I went there.
You met her the same day?
The day she sent me this email with the appointment date on there, I showed her on the appointment date.
Okay. So you made an appointment
She made an appointment to go there, for me to go there.
on the 22nd. You made the appointment for some time in the future, right?
Yes, but she did. She told me when to go there.
Okay. And to go there meant to go where?
To go to the leasing of, the clubhouse.
The clubhouse for the neighborhood.
Yes,
And you met with Ms. Jackson.
yes.
Okay.
All right. And what happened at that meeting?
Well, Miss Jackson told me, I didn't know who she was. I just know the name Melanie Jackson. I really didn't know who she was. But I walked there and I asked for Beth Howard. And then she said, I'm Melanie Jackson. I'm the one he's supposed to meet. And we had a little conversation, me and her. So she said, but I can't meet you today. Beth is not here. So I like, okay, Beth sent me an email to meet you, but I want to see the Beth herself because the email she sent me, I found it offensive. And she said, what do you mean? And I explained to her that the email looked insulting because I rented the house. I didn't dispute that. But I didn't know that I was not supposed to rent the house without paying fees or leasing fees. But the email Ben sent me, that she telling me that I'm a liar or I don't have truth in me from what I read. It's like you are not honest or forthcoming with the bull. So like she didn't ask me before this letter that, hey, did you rent your house? And I refused. She didn't ask me that question. So it was a first letter to me that telling me now that I did not tell the bull the truth about renting the property. I didn't know that. So she said, well, we can't see you. You have to come back. In less than 2, 3, 4 minutes, that happened, says you all there. And I told her, I said, I didn't like the email you sent me. I found it offensive because guess what? You did not ask me before that you rent a house and I lied about it. This is your first letter and you write me a letter like that, like you're insulting me. I'm not a liar.
Okay, well, we got that part of it. What was the discussion about how to get yourself in compliance with the board?
Okay, so then she told me, well, you have to come back another time. We got other people to take care of. So I said, well, I need to come here if you got a time, give me a date. And the only time that I have is on a weekend. She said, well, and Kendrick is another girl that worked named Kendrick. She said, well, we'll send you an email to tell you when to meet again. I never got that email. So I kept calling the Kendrick. I would call her and then she would not respond. I got so tired with her.
Who were you calling?
There's another lady that works in the office that is called Kendrick. Yeah.
Kendrick.
Yes.
Okay.
So she said, well, we can't see you now, but we'll make up a time for you to come back. So then I left. So I told her when I was leaving that I can only be there on a weekend because that's the time that I got off. When I off the road, that's when I'm home. She said, we will send you a date. And then I left.
Okay.
Yeah.
Now, if you look at plaintiff's exhibit 5, see that?
Yes.
This is another letter from the association. Did you get this letter? Do you recall this?
No.
Okay. Now this letter is sent to the address where you used to live, right?
Yeah.
Did you ever tell them that you moved and they needed to send letters to a different place?
Yes, I told Beckham in person. I told her the address and everything, and she wrote it down before.
Okay. Was that before June the 8th or after?
That was before June the 8th because
Okay.
when I the very day that I talked to them, I told them, I said, I'm not there. And she, I mean, can you give her your address? So I gave her my address. It's just 1 mile away from where I moved, 2 miles from where I moved.
But Beth Harper wrote your address down.
Yeah, she did it with a pen.
Okay. So you don't remember receiving exhibit 5?
No.
Okay. All right, look at exhibit 6. This is an email from Charlene Alexander. That's your wife, right?
Yes.
And this was sent October 25th, right?
Yes.
And then there's a response from Beth, which is Beth Harper, on the 28th.
Yes.
And it looks like the upshot of this is that a meeting is set for November the 9th.
Yes.
Is that what that says?
Yes.
She arranged for you to meet on the 9th. Okay. And then if you look at the next exhibit, exhibit 8, you can turn that one over and look at the next one. This is a confirmation from Charlene, your wife, to the board. We'll be there on the 9th,
Yes.
correct?
Yes.
And if you'll now look at exhibit 9. On November 9th, did you go to the clubhouse?
Yes, sir.
Okay, was anybody there to meet with you?
No.
Did you wait for them to show up?
Yeah, me and my wife sat in the parking lot for
Did-
1 hour or 2.
Did you send them an email and say, where are you? Is that what exhibit 9 is?
My wife did.
Okay. And they told you that the meeting had been reset for November 17th.
Yes.
Okay. And if you look at the next email, that's again from Beth, from your wife to Beth,
Yeah.
essentially complaining about the rescheduling without telling you.
Yes.
Okay. Now, then, did you meet on the 17th with somebody about the lease? You can turn that over now. But don't look at the next exhibit yet. Did you then meet on the 17th of 2019 with somebody from Greystone?
Yes, I think so, yeah.
All right, and what happened at that?
Well, at that meeting, we discussed, I think she asked me, and I told her, she asked me for the lease. And at the time, I told her I didn't have the lease with me. So I told her, I said, well, I was willing to pay the leasing fine just so I can have the property rented. So at least I can make money to pay my mortgage. And she said, no, we can't do that. And then she said, if I don't have it, they will put the house on foreclose. She the best made that statement that she will foreclose the house to the bank or something like that. But
Okay.
I don't know what foreclose is and stuff like that. So
So what did you offer to pay? How much money?
I offer to pay now.
Before we go on, this is, you are now at the clubhouse on November 17th at a board meeting.
Yes.
It's not just a meeting with you and Ms. Harper, but the whole board is there?
Yes, I think yes. Yeah.
How many people are on the board?
I don't know.
1, 2, 3, 10? I'm not asking you who they are, but how many people?
I think 4 or 5.
4 or 5? And your testimony is they were all there on the 17th?
I think so. I think all of them was there.
Okay. And you said that they wanted a copy of the lease.
Yeah.
That you did not have.
Yes.
And you said you offered to pay the leasing fine. What do you mean by that? How much money did you offer to pay?
$1,000.
Okay. So that's the fee to apply to lease, right?
Yes.
That's not really a fine. That's the cost of the application.
Yes.
You offered to pay that.
Yeah.
And anything else discussed at that meeting?
Yeah, she said no. They said no. They can't do it until I go bring the lease.
Okay. And then if you look at Exhibit 11, and these emails are, the first email is at the bottom. So you sent an email to the board on November 18th, the next day, thanking them for the meeting and telling them you couldn't find the lease, and again offering to pay the $1,000. And you also told them here that the tenant doesn't live there anymore.
Yes.
Then they responded on December 7th. That's the email at the top, right?
Yes.
And they told you that this will not suffice. They need the rent or the lease. They need a copy of the eviction, etc.
Yes.
And that you could not lease the property until the issue was resolved.
Yes.
Is that right?
Yes.
Now, at that point, you came to my office.
Yes.
All right. And the next exhibit, what is that? That's the letter that I wrote, correct?
Yes, sir.
Okay. And this was directed to Beth Harper, who was the president of the association.
Yes.
Okay. And the judge can read it for himself, but essentially it makes the same proposal that you pay the $1,000 and a $250 fine. Now, let me ask you this, you can turn that over. At this point, did you know that they were fining you $15,500 for the lease?
No.
Okay. There is a ledger in the exhibits. Let me just show it to you. Exhibit 15. Did you get bills periodically from Greystone?
No.
How did they tell you how much you owe? How did you know how much to pay? Did they email you, or did they write you or send you a bill, or did you just have to know?
No. You know what? I think she sent me a bill for $15,500.
Okay.
Yeah.
What about the annual dues? Was there annual dues for Greystone?
Yes.
And those were $495,
No,
I think?
it used to be $395 or $96.
Okay.
Yeah.
How did you pay? Did they send you a bill for that?
Yeah, they send me that bill every year. I think it's due in February or something like that. No.
You always pay that, right?
Yes.
But this $15,500 fine, do you know when you first learned of that and how you learned of it?
Yeah, I don't know the date that, I can't recall the date she sent it to me, but it was some time after. And then she sent me that bill, and I think I gave it to you.
After the meeting on November 17th?
Yeah, I think so, or before that, one of them.
Well, it's one or the other. Had you already started working with Mr. Moulton when you got the bill for $15,000? Or did the bill come to you before you reached out to Mr. Moulton for help?
Yeah, I think the bill came to me before.
Well, it clearly did, because if you read Exhibit 12, I'm complaining about the size of the,
I'm just trying to figure out what he remembers.
yes, sir.
What Mr. Clarke remembers.
Yes, sir. Now, do you recall any response to the letter that I sent December 12th? From the board?
Yeah, I think she sent a letter back after a long period.
Well, look at plaintiff's exhibit 13, the next exhibit. You see that letter?
Yeah.
And that's dated January the 20th?
Yes.
And this is from Greystone to you?
Yeah.
And this document also tells you that you have leasing violations, correct?
Yes.
We're looking at 13. What exhibit?
Yes, Judge.
Okay.
It does not say how much the leasing fines are, does it?
No.
It also tells you need to refresh your flower beds,
Yes.
remove the tree trunk,
Yes.
fix the pavers, and trim the shrubs.
Yeah.
And that you will, you have 10 days to appeal it, or you have 10 days to take corrective action.
Yes.
And you have 10 days to ask for a formal hearing, or request a hearing. Is that what it says, the bottom there?
Yeah.
All right, and did you bring this letter to my attention?
Yes.
Sorry, to use some of that all together. Show you exhibit 29. Do you see the email that I sent to Ms. Harper at the bottom there?
Yes, sir.
And did I ask for a formal hearing in that letter?
Yes.
And what did she say in response?
She said, go to a lawyer, Pastel.
That I needed to work with Mr. Pastel.
Yeah.
And she also says that you had already had your hearing.
Yeah.
In that email?
Yeah.
The board has already had a meeting with Mr. Clarke about this?
Yeah.
Okay. But that meeting didn't resolve anything to your satisfaction, had it?
No.
Okay. And after that exchange is when we filed this case, is that correct?
Yes, sir.
All right. Now let's talk about the stump for a minute. You had a tree in your yard,
Yes.
and did you take it upon yourself to prune the tree?
Yes.
Was the tree dead?
No.
And, we're slightly out of order here, but this plaintiff's exhibit 18, is that a picture of the tree?
Yeah.
This is after you pruned it?
Yeah.
Your words? Okay. And you
Promise me you will never prune any of my trees.
And you put these pavers around it and the mulch, is that right?
Yes.
And you wanted to grow the tree there, correct? Okay.
Mr. Clarke, is your house, as we look at this picture, is your house the one on the left where we see some of the garage, or is your house the one on the right where we only see the HVAC units?
My house is on the left.
All right. Now, you had actually gotten some notice about this tree before the lease issue came up. Is that right?
Yes.
Okay. And you, I think, responded, and I don't want to burden the court, but you responded that you don't need to remove the tree because it's alive.
Yes.
The association said it's got to remove a dead tree.
Yeah.
And you said, well, it's not dead, it's alive,
Yes.
right? Okay. But now in January 2020, we're bringing this up again.
Yes.
And so then we have a letter here from Mr. Pastel on Exhibit 14, which is April 27th.
Yeah.
Right?
Exhibit what number?
14.
14.
And this is after the case had been filed.
Yeah.
And this letter tells you that you have to keep your property in an attractive condition and that this tree doesn't meet that standard, right?
Yeah.
And that you had a chance to get a hearing on this, but you didn't request a hearing, right?
No.
And it says that you're going to be fined $25 a day until you do something about this, right?
Yes.
And then it says that there's an outstanding fine for a leasing violation, right?
Yeah.
And Mr. Pastel says that you're being fined $1,250 a month for your leasing violation, right?
Yeah.
Okay. Now, did you decide to get rid of the tree?
Yeah.
Just wasn't worth the hassle, basically, right?
Yeah.
Now, you look at Planners 19, is that the work we did?
Yeah.
And how did you have to rent equipment, get rid of the tree and the stump?
Yeah, I went to Home Depot and got a chainsaw, and I got some machine that I own in my garage.
Okay,
Yeah, lawnmower equipment and stuff like that, and I removed the whole tree itself.
okay. And when did you do that?
I did it, I think it was on June the 6th, Saturday, June the 6th.
2020.
Yes.
Okay. Now, did you leave the ring with the mulch in it?
Yeah,
Okay.
I put mulch in it.
And this looks like it's kind of in an area between your house and the neighbor's house.
Yes.
Now, if the association had been willing to work with you, would you have rented the house out again?
I'm just going to object to the way you phrased the question. The presumed evidence, not in I mean, facts not in evidence.
Let me see if I can rephrase.
I think I get the point of your question, and there's a dispute as to whether the association was working with Mr. Clarke or not. But I think from your perspective, Mr. Moulton, it's a fair question. I bet Mr. Pastel would ask the question differently, but the answer is really what matters here.
You wanted to keep this house as a rental property, right?
Yes, I want to keep the house itself. I don't know.
And after Mr. Iglesias was evicted, had this issue with the association not come up, you would have re-rented the property to another tenant, right?
Yes.
And you had engaged a property management company to help you and advise you on how to do that. And they helped you with that lease form and with the eviction and so forth?
Yeah.
Okay. And Mr. Iglesias was paying $1,550 per month in rent.
Yes.
And I think you told me the agreement with him was that he would also cut the grass.
Yeah.
And that it would have rented for a little more, but since he was going to mow the grass and that kind of thing,
Yeah.
he got a little bit of a discount, right?
Yeah, $1,595. That was the rental, actually the rental amount.
$1,595 was what you thought the house should rent for.
Yes.
Okay. And you arrived at that number in consultation with this management company.
Yes.
Okay. And that you were unable to make any efforts to re-rent the house after this whole issue with Greystone came up, correct?
Say that again?
You were unable to re-rent the house because you couldn't get a leasing permit, correct?
Yeah.
And at least by November, you knew that they were going to fine you the full amount of the rent for any month that a tenant was there without a permit, right?
Yeah.
You continued to own the house until January of this year, is that right?
Yes,
And then you sold it.
yes.
And at the sale, if you look at Exhibit 3, I'll just hand you Exhibit 3. Oh, you got it right there. Is this the closing statement from your sale?
Yes.
Did you understand that out of the proceeds of your money from the sale price, that the closing attorney sent Greystone $26,379.90?
Yeah.
You did not want to sell the house, did you, Mr. Clarke?
No,
Did you feel like you had any choice in the matter?
no.
Was there anything you could do with this house to generate income or realize the value of the house aside from selling it?
I wanted to keep the house. I wanted to keep it for my daughter.
I think you'd have to pull that up, sir.
That's right. Take a minute, Mr. Clarke. This is fine. You take a minute and should we take a break?
I wanted to keep my house for my daughter, my children. I didn't want to sell it. I just want to keep it for my children. That's it. If I die, let me leave something behind for my children. My son wants to be a doctor. I wanted to raise the money to pay for my son.
Why don't we take a quick break? It is, according to my clock here, a little before 10:40. Why don't we reconvene around 10:45? And if people need more time, that's fine, but we'll stop until 10:45, okay? So, Mr. Clarke, we're going to take a break. You're free to step outside if you need to, and at 10:45, we'll pick up where we left off. Thank you.
Well, point of order.
You all can be seated. Thank you. All right, Mr. Clarke, you doing better? If you ever need a break, let me know. This is not a forced march, and that goes for the attorneys as well. If we need to pause, pausing is fine. I do want us to get through this, but we should break when we need it. So Mr. Clarke was explaining that he did not want to sell 1136. The fact that it sold in January of 21 is more a product of there's nothing else I can do with it because I can't lease it, but that he had hoped to keep it as a rent generating property until his kids could use it when they were old enough to need a place of their own. That's where we, I think, left off, Mr. Moulton.
And you heard what the judge said. Is that accurate as far as your attitude about it?
Yes, sir.
All right. And you basically felt like you had no choice but to sell the house. Let me show you. Plaintiff's Exhibit 17. So, change your mind. Is that the mailbox at your house?
Yes.
And that is after you remove the white rocks? obviously.
Yes,
With the white rocks, was I right when I described it? Were inside the pavers?
it was, the white rock was in the ground around the mailbox.
And what was the date that you fixed the mailbox?
I think the mailbox fixed it.
There's some notes on the reverse of the,
The 18, yeah, the 3rd, the 18th.
say that again?
I fixed it on the 3rd, the 18th,
What year are we talking about?
2020.
March 13th, is that?
March 18th.
Okay.
This is also, I think you were told you needed to trim some bushes and flower beds. Is that same day you did all of that?
Yeah.
Let me show you what I've marked, plan 16. Recognize that as a schedule from the association?
I'm looking at 16. It looks like a bill.
It's actually something that was sent in litigation of, actually this, you asked for this at the motion hearing, Judge, and Attorney Chad Reynolds, I believe.
Yes.
Emailed this to you.
Okay.
This was the sort of the status on the day we were in court.
Sure. So it's a ledger. You say schedule. I think of schedule as at 3 p.m. we'll be here, but this is a history, if I follow it. In February of 2018, Mr. Clarke was assessed $395 regular member assessment. He didn't pay it, so there's a delinquent fee, and then he paid.
So this is his account, all the entries on his account from February 18 to September 2020. And Mr. Clarke, you see the fine August 9th, 2019, the $15,500 fine was entered.
Yeah.
And then there was a $100 fine for the white rocks.
Yeah.
And there was another assessment or annual due, and that was paid, correct?
Yes.
And then there's attorney's fees on down to the tree trunk replacement on September 30th.
Yeah.
That was a $25 a day fine. See that?
Yeah.
But that tree was actually removed June the 6th, as you testified before, not.
Saturday, June 6th, yeah.
Okay. And so it appears that the leasing fine had already been assessed long before your meeting in November with the board, right? And long before the attempted meeting on October the 9th, right? Now let me show you Plans Exhibit 23. That a statement of your account with me?
Yes. This is how much I paid.
And you hired me on an hourly basis, is that right?
Yes, sir.
And those are the entries, the hours that were worked for your case since the beginning till a couple of days ago,
Yes.
correct?
Yeah.
Okay. Judge, I'll testify about that later.
Can you remind me, Mr. Clarke, because I didn't write it down, how is it that you recall that the stump was removed on the day you say it was removed? We talked about the picture. I saw two different pictures, one of the pruned tree and then the removed one, and you said you got a chainsaw and some equipment in your garage.
Yeah. What happened is when I removed the saw, I stood right there and took the pictures and sent it to him.
Okay.
Yeah, and
So the day you removed it, you took the pictures and sent it. So the date of the picture would be the date of the removal.
Yes.
And that's June 6th.
Yes.
Okay.
Number of weeks, did you get to 34?
Yeah, so that'd be 35.
Show you what I marked, plan is 35. And to the judge's point there, You sent the picture of the removed stump to me on the day you did it,
Yeah.
or the day after you did it? Is that right?
It is here. Okay, I removed the tree stump on the 6th of June. That's Saturday. That was Saturday.
Day did you send me that picture?
I think I sent the picture to you.
Right here, sir.
Yeah.
June the 6th,
Yeah.
2020.
Yeah.
Sent me a picture of the removed stump, right?
Yeah.
And that's the email you sent, right?
Yes.
The picture.
Yeah.
Because that one was not included in our package, so I'll move to get on 35.
And that's the email with the attached photo.
Yes.
All right, any objection, Mr. Pastel? That's admitted.
I believe that's all the questions I have for Mr. Clarke this time. And just to make sure we're on the same page, all the exhibits are in the record already. I don't need to.
Sure, even the ones you haven't shared with your client, you may have covered them all. I wasn't checking them off, but what I heard you and Mr. Pastel agree to is, I've looked at all of Mr. Pastel's exhibits, no issue having them come in. No one needs to authenticate them, anything like that. And then I heard Mr. Pastel say the same about yours, with the one caveat being the one you just entered, but I heard Mr. Pastel say he does not object to that one. He just didn't have it before this session.
Why don't you give 35 up to the judges so it's.
He can hand it to me. That's fine. From right here. He just needs to find it. Is that it? Thank you, sir. I'm going to give this back to you. All right. Mr. Pastel. Great.
Mr. Clarke, I'm Marvin Pascal. I'm the attorney for the association. Glad to meet you this morning. We have never met before, have we?
No, sir. Nice to meet you.
Okay. And as I understand it, you're a truck driver, is that correct?
Yes.
And you do long hauls?
I used to, now I don't.
Okay, well, back at the relevant time in 2018, 19, and 20, were you doing long hauls?
Yes.
Okay.
And long haul for you means all the way to California, or does that mean to Conyers?
It depends. California? No, I didn't do California, but I'll be Carolina.
Out of state.
Out of state.
Okay.
Sometimes out of state, sometimes local. It depends where they send me.
It's not unusual for you to be out of town for a week at a time, so.
No, sometimes I'm out of town.
Right.
But most weekend, I come back home.
Okay, so you try to just keep it to the weekdays, correct?
Yeah.
Okay. At the time you entered into that lease with Mr. Inglese, you agree you did not tell the association that you were leasing the property, correct?
Yes.
Okay. In fact, as you testified, you weren't even aware that there was a leasing provision, correct?
Yeah.
In fact, as you testified, you hadn't even read through the governing documents, correct?
Mr. Pastel, you've referred, I think, a couple times to your client as a POA. I've been
Okay.
in my, no. I just want to make sure I understand. Property Owners Association?
Yes, they are subjected to the Property Owners Association statute.
Not HOA.
Well, there is no HOA statute. It gets a little confusing.
Okay.
There are essentially three types of community associations.
Condos, you talking
Condos,
about.
and there's a condo statute.
Yeah, yes, there is.
POAs, which are covered by the Property Owners Association Act, and then everything else we refer to as an HOA.
Okay,
An HOA is really no more than the agreement of the declaration you have between it. You have no statutory overlay.
so when I have these cases that are brought by such and such HOA versus the homeowner who hasn't paid assessments, that may actually be a POA.
Absolutely, it could even be a condo.
Okay,
Just, right, you cannot tell by the name.
okay, got it. But what we're dealing with here, legally, the structure of Greystone is a POA.
That is correct.
Okay, thank you.
That is correct. That is correct.
Sorry for the interruption.
No, I appreciate the opportunity. So, but at the time you moved in, you knew you were moving into a community that had governing documents, correct?
Yeah.
Yeah, and you knew you had to pay annual assessments, correct?
Yeah.
Okay. Now, I don't want to belabor it too much, but I want to make sure we do drive this point home. Prior to Mr. Inglese moving into your home to rent, you never told the association of your intent to lease, correct?
Yes,
You did not give the association a copy of the lease, correct?
yes,
And you did not ever give the association your off-site living address where you were moving to.
I gave my, I'm there in meeting.
At the meeting, that's the first time you're claiming you gave them your off-site living address.
When you moved out to your new house, you did not tell the POA, oh, by the way, I'm going to be living at 123 Main Street.
Yeah, no, I didn't do it.
You did not. Okay.
Did not.
That's all I think he's asking.
That's all I was asking at this time, yes. And you did not get a tenant screening for Mr. Inglese, did you? You know what I mean when I talk to about a tenant screening? Let me ask you this, right? Do you know what a third-party tenant screening is?
No.
No. Well, let me just ask it this way. Have you read through the leasing provisions to understand what's required under the leasing provisions?
No,
A big pardon?
no,
No. Okay. So as we sit here today, you still don't know the requirements in the leasing provisions, correct?
now I know some now.
Big pardon?
Now I know that.
Now you do, right. Because you heard me in my opening mention the 12 things you got to do, correct? But that's the first time you knew of all those items, correct?
Yeah.
Yes, that's a yes. Okay. 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 So let's handle it this way. Did you ever give the association your off-site living address in a communication other than oral? Other than an oral communication? Did you ever email it to Beth Harper or anybody else, send them a letter, a text, anything with your new address other than through an oral, through your mouth communication?
No,
Okay. And you're claiming that you did that at that Sunday meeting on November 17th, correct?
Yes.
Okay. Now, at that meeting on November 17th, the association told you that they wanted to see a copy of the lease, correct?
yes,
At that meeting on November 17th, you knew you were being fined, correct? For your leasing violation. You knew that the association was fining you for the lease for your leasing.
Yeah.
Right. And part of the Sunday, November 17th meeting was to talk about would some of that fine be waived, correct?
say that again.
On Sunday, November 17th, was any of the discussion, well, would you, HOA, please reduce the fine? Did that topic come up?
No,
So you never, on November 17th, you did not ask the association to reduce your fines?
we didn't discuss fine. They only told me they were going to fine me, and then I should bring the lease.
Right.
So we didn't have the chance to say, okay, I paid it. Oh, I think my wife did. I think my wife told them that we're going to pay now $1,000 and said no.
They told you that the intent was to fine you the amount of your rent, correct?
Say that again.
Okay, on November 17th, let me back up a little bit. Do you see Melanie Jackson in the picture there?
Yeah.
Okay. Was she at the meeting on November 17th?
Yeah, I think she was there, yeah.
You think, you're not sure though?
So she was there.
Okay. She was there? Okay. And if you go over, do you see Beth Rodriguez, Beth Harper?
Yes,
She's not, well, she was there at the meeting on November 17th, correct?
yes.
Okay. And in fact, there was at least one other board member, but you don't know their name, correct?
No.
Okay. They also told you that they wanted to see a copy of your eviction papers for the tenant, correct?
Yes,
Okay. And they never said you cannot lease no matter what you do until you pay the $15,000. They never said that at the meeting,
she
did
said
they?
it.
She said what?
She said to pay the fine before I can get a leasing permit.
And how much was that fine?
The amount you just got, $15,000.
Okay, so on November 17th, you knew the fine was $15,500. Is that correct?
Yes,
Okay. And it's your testimony that they said until you pay the $15,500, we're not going to let you lease. Is that what you heard?
yes,
You did not, your testimony is that they weren't going to discuss this matter any further.
yes.
Okay. And at no point after Mr. Inglese moved out, did you ever advertise your home for rent to try to find a tenant, did you?
I did.
You did?
Yeah, I went to a leasing company.
You went to a leasing company to ask. Did you actually sign papers and sign up with the leasing company?
No, I just told them I wanted to rent the house. I thought I was going to get the permission to rent the house after the court hearing.
Okay. Did they ever present a suitable tenant to you?
Well, I never got to the point where I was getting a tenant, but they had sent me a document telling me the house, how much it's going to rent for.
Okay. Now, let me.
Mr. Clarke, while Mr. Pastel's getting that very large red well,
Go ahead.
your tenant was evicted in July of 2019. He may have moved out before then, you said. So after that date, the house is unoccupied. Mail shows up all the time. It can be junk mail. It could be something in your name and it didn't get forwarded. It could be something in Mr. Iglesias's name. What steps did you take to check the mail at 1136 Old Greystone when there was no longer a tenant in the house?
I always go to get the mail.
Say that again?
I always get the mail.
So you would get the mail from
Yeah,
there?
I'll go there and take the mail if it's in my name.
Okay,
Take it out. If it's not in my name, I leave it there for the guy.
okay. But once the guy was out, then you just take everything that was in the mailbox?
No, the one that belongs to me, I will take it. Sometimes they open for me, my sister, or my wife. I will take that one. Then the one that belongs to the guy, I will leave it.
Okay.
Now, Exhibit 5,
These are now defense exhibits?
we just got the same number for all of them. I mean, the plaintiff's exhibits are also defendant's exhibits.
Oh, I didn't realize. So it's just generic exhibits?
Yes.
Got it. That's very helpful.
Right.
Thank you.
That's correct.
Great. So exhibit 5 is everyone's exhibit 5.
I just told Monica I wasn't gonna duplicate all of them and
Okay,
clutter up your thoughts.
I will find Exhibit 5.
And you have that in front of you. Exhibit 5, Mr. Clarke, is a letter the association sent you on June 8th, 2019. And that was before the meeting that you told them where you lived. Are you saying you did not get Exhibit 5 in the mail? It was addressed to your house.
1136.
Right.
I don't know if it helps. I have it up on the screen. If you want to see it, that's Exhibit 5. So it's to you at the address. And I just asked you, would you check the mailbox? And you said, I check it all the time. It was addressed to me or my wife or your sister or her sister. You'd get the mail. So Mr. Pastel's question is, did you ever get the letter you see right there?
Yes.
You think you did get it?
Yes.
Okay.
Okay. And if you, Your Honor, could do the same with Exhibit 30, that would save me the.
Taxing
Move to
me
back
here.
up.
Let's see. Okay. Exhibit 30. I got it. All right. Is that on the screen now?
Yes, thank you, Your Honor. Do you recall getting Exhibit 30? This would have been like a couple weeks before. It's the same date as an email to you about this issue.
Yes.
Yes, is that correct? Okay, you recall getting that letter, right? And we already went through all the emails that were back and forth and stuff like that. All right. When did you finally provide the association with a copy of your lease? The one you had with Mr. Inglesi?
I'll give it to the lawyer.
Right. So you never provided it to the,
I'll give it to Antonio.
you gave it to your attorney? Yes, yes, okay. You never, let's see. I put Exhibit 31 in front of you, but if you want to pull it up on the screen, Your Honor. It's up on the corner there, Mr. Clarke, on the, near the tissues.
Okay. It's also on the screen now. Whichever is easier for you.
Now, at this time, I believe your tenant was living in the house. The letter's still addressed to the house. You would agree the association didn't have anywhere else to mail the letter to. Did you receive a copy of this letter?
Yes.
Yes, you did, correct? Right. And that's the same tree you removed on June 6th of 2020, correct?
Yes.
Okay.
What was the situation with the abandoned vehicle? No one's complained about that, so that must have gone away. Was that Mr. Iglesias's car or your car?
No, I bought this car because I wanted to send it to Africa, but the mission was broken. When I moved, I left it there.
Okay. And what happened with it?
I moved it.
Because you got this letter?
Yeah.
Okay. Did the car make it to Africa? Not so much.
The car was forcing more to go to Africa than the money I bought it for. So
Well, it was a good idea.
So staying on the stump for a moment here, you never told the association that you removed the stump, did you?
I told them I was going to remove it. I'm going to repair the windshield on the car.
No, we're on the stump. Back in June 6, 2020, you removed the stump.
Yes.
Did you tell the association, hey, send them an email, text, letter, hey, I removed the stump, stop the fines? Did you ever do that?
I removed it. I took the information and gave it to the lawyer.
Okay. Right. But you did not communicate with the HOA yourself about the stump having been removed?
Because I couldn't communicate with the animal because guess what? I know every communication to them will be like go to the attorney. So all I had to do was go to my lawyer and he passed that information to me.
Right. All right. And then if you want to put exhibit 25 on the screen. All right. Do you recall seeing that communication?
So this was not sent to Mr. Clarke. I mean, he may have seen it, but you're not alleging that this was directed to Mr.
This was
Clarke.
my email to his attorney.
Yep.
He just testified. He thinks all communication's gone through to the attorney. I'm assuming his attorney's, whatever.
Okay.
I mean, have you seen this before? There's other stuff that's redacted because it's not relevant to the case. I want you to, but did you ever provide the stump invoice or the Home Depot invoice to your attorney?
I think I did, but I can't recall.
You think you did? Okay. All right. The next one, Your Honor, is exhibit 26. This is going to be essentially a two-page document, Mr. Clarke, but do you recall seeing this document either at closing or before closing?
I'm just looking at
Yeah.
the next page.
No, I appreciate that.
Yeah, I got it there at the closing.
I beg your pardon? You received it at closing?
Yeah.
Okay. And you see in the red writing there at the very last bottom, it says, please note there is a current violation on the property in the front yard consisting of a circular row of bricks and lack of grass inside the circle. All right. And you received this at closing, correct? Prior to closing, did you receive a copy of this court's order stating that you could lease the property?
Yes.
Okay. And instead of leasing the property, you elected to sell the property, correct?
Yes.
And at the time of the sale, you were fully aware that the association was seeking $15,500 as part of its, for the leasing violation, correct?
Yes.
And at the time of closing, you were fully aware that there was the trunk violation charge for the tree trunk of $3,920, correct?
Yeah.
And at the time of closing, there was this $100 white rock issue, correct?
Yeah.
All right. And then you knew about our attorney's fees, correct?
Yeah.
Right. In fact, on Ledger 16 at the time of TRO hearing, did you attend the TRO hearing, by the way? You did. Okay, so you were present when the lawyers made arguments to the court, correct? Okay. Did you hear the argument to the court that one of the reasons you needed to be able to lease your property was to make your mortgage payments?
That mortgage was for my house and I live
You
in.
meant, okay, so you thought they were always talking about the house that you lived in. Okay, that's fine. Was it your idea to ask the court if you could rent the house, to file a motion to see if you could rent the house or somehow get the court to give you permission?
Yeah.
Okay. Prior to closing, did you ever ask if the court would accept putting into the registry the money that the association was seeking at closing?
After closing, I told me to do that. He refused.
Okay.
Say that again?
The closing, I told him, I asked him if he can put that money into the court, or if the court can hold that money till the case is settled himself. He can't do it because it's the government and he have to pay the people. The buyer was there, so
Right.
the buyer will not accept it.
Okay.
Prior to the closing, did you ever think about getting a bond on the property to take care of the violation fines?
No, I don't know. I never had any idea about the bond. Reason actually because I had no choice. It was like I had to pay the taxes, I had to pay all the bills and stuff like that. And I'm making money, so I was just pushed against the wall.
What about getting a mortgage on the property? Did you ever try to apply for a mortgage on the property?
So
And you're talking about a mortgage
On-
on 1136.
1136.
Okay.
Right. Did you ever think about getting a mortgage for 1136?
I didn't want to get the animal debt, and I already had.
You just didn't want the debt.
No.
Okay. So you knew it was an option to get a mortgage on the property, but you just
Okay, so
didn't
you
want
need to wait till he finishes his question, then you talk. He won't interrupt you either, okay?
So you knew about the option to get a mortgage on the property at 1136. You just personally did not want any more debt.
I didn't know if I had an option to go get a mortgage on the property because I already had one with mortgage on it. So I didn't want to go get a second mortgage and put me to more debt that I couldn't afford.
Did you think about a line of credit on the property? We call it a home equity line of credit, a HELOC, so that you could pay taxes if you wanted to, or have other expenses that you felt you had?
No. See, I just didn't want to go take more debt than what I already had.
Right. What are the age of your kids?
I got a 11 years old, I got a 8 years old, and I got a 6 years old.
11, 8, and 6. Okay. Okay, that's all I have, Your Honor.
I don't have any further questions for Mr. Clarke.
No redirect for Mr. Clarke. Mr. Clarke, I thought I had one more question, but I'm trying to remember it based on the notes I was taking. Well, I know how to find you if I remember today. Okay, thank you. You're free to step down. You can leave all the papers there, and you can go back and sit with Mr. Moulton. Thank you so much. Mr. Moulton?
Judge, I'm happy to handle the attorney's fees issue however you would prefer. I can stand at the podium and testify. I can.
With Mr. Pastel's concurrence, I would actually like to hear from Ms. Harper/Rodriguez next, because that is more directly connected to what I just heard. Your fees are what they are, and we'll work through that, and I'll let you state in your place. Mr. Pastel may need to ask you some questions. If you need to be under oath, we'll do that, but those are, to me, sufficiently separate that I'd rather connect the dots with the witness testimony Mr. Pastel wants to provide. And you did mention, Mr. Pastel, you might have more to say when you're testifying than just attorney's fees. So if part of your testimony would go to what we've been exploring with Mr. Clarke, you could provide that as well. And when we've agreed that we've presented the evidence as to what I'll call the substantive issues, not that attorney's fees are non-substantive, then we can pivot back. Does that work for you?
Well, with one clarification, I just want to clarify, other than Mr. Moulton's testimony, you're done with your case, resting?
Subject to how the court wants to hear about the attorney's fees, we're resting our case.
Okay.
I mean, at this time, Your Honor, I'd like to move for a directed verdict.
Okay.
I wanted to. I mean, especially on the count for the refund, the voluntary payment. Paper on this. And I'm going to do both. My position, both counts are, moot at this stage. I provided two cases to the court that I'll concentrate on. One is Yetzel versus Burger King. And the other.
When you say provided, I've got them electronically or you have them physically?
I got them both.
Okay. Thank
These
you.
are on the voluntary payment document.
Just so I'm clear, the amended complaint, does it still push forward count one, the declaratory judgment about the enforceability of the fine, and then breach? I mean, it's the same two, but you've fleshed it out. Or are there different counts now that there's an amended
Well, I
complaint?
think the declaratory judgment is probably moot at this point, but the breach of contract is still alive.
And why do you say the declaratory judgment is moot?
Well, it's moot in a sense, that the breach of contract is that the fine, part of it is that the leasing fine is an unenforceable penalty. And that therefore their demand that he pay that before he can even submit an application breaches the covenants and caused financial harm to him. So declaring it to be an unenforceable penalty is sort of a subset of the breach of contract claim.
Okay. All right. Wow.
I look at it as two, well, a lot of that's kind of why I normally don't highlight cases for the court, but I did on this one because it is so thick, but most of it's on a different issue that we're not going to address. But I look at what they're looking for, as I say, three things. One, the refund of the payment we made. Two, my lost rent. And three, attorney's fees. Right? Now, the attorney's fees would travel with the first two, so I'm moving on the first two. And the first one, I want a refund of what I paid. I'm saying is barred by 13.113, called the voluntary payment doctrine. And I showed you the statute earlier, but I'd like to emphasize, and the Burger King case is going to do the same thing, but I want to emphasize that the statute's a strict statute. The last sentence of it reads, following a protest at the time of payment does not change this rule described in this section. So you just can't pay under protest, doesn't get you off the hook, right? You got, and that's why he's trying to allege that there was an urgent and immediate necessity to release the property and to keep it from being seized, right?
So let me stop you for a moment. There's a threshold question of, was the fine proper, fair, just, et cetera, to begin with? You're saying that's waived?
No, that's gone. I mean, that's not an issue for the voluntary payment doctrine. In fact, in the Burger King case, right, now why don't I jump into that? Because that ironically, I believe, is one of the questions they were addressing, right? There was a declaratory action about whether a $4,000 monthly base payment was applicable, right? And Burger King was a tenant, but the tenant said, I don't think it's applicable. Well, they paid it during the litigation and stuff, and the trial court actually found that, yeah, you shouldn't have to pay the $4,000, pay it back. And the appellate court said, no, not so fast, right. In fact, it doesn't matter the outcome of the declaratory judgment. That's on page 5. It's true until the court rules on the issue, Burger King couldn't be sure whether the court would agree with its interpretation. But that's irrelevant, whether it's a valid fine, a valid charge or not. The question is, did they have all the facts to make a decision about whether or not to pay it? And definitely on the leasing charge, they had all the information in front of them, right? Decide, do I want to pay it or do I want to keep fighting in court? So that's really what that first paragraph talks about there in the Burger King case. You don't know how the court's going to come out, but that's not important about the voluntary payment statute. Right? And I believe I can even find, I didn't bother bringing them, but some cases about that it doesn't matter if it's a wrong charge or not. If you have the facts and you pay it, right, you've done it. I want to then go to the next column on page 5 of the Burger King case, because that's when we get to some discussion here, that Georgia courts have strictly interpreted the requirement that to be recoverable, a payment must be made under a, quote, urgent and immediate, end quote, necessity, or to prevent, end quote, immediate seizure. And then they give an example. A threat to levy on a judgment if payment is not made does not constitute such an immediate threat. That's a levy on a judgment, right? Then they talk about a threat of a lawsuit, right? On the following page, they do talk about, all right, if you're going to do non-judicial eviction of the rent space, we could see how maybe that's an immediate seizure, right? And we could do that. But clearly not once you're in court and this matter is going on, you don't need to continue to make the payments. So, and I will tell you, I did not, in my research, find any case law under the statute that upheld or really did any more talk about an immediate, this clause that they're going under, immediate and urgency, and to prevent a seizure on there. This was the closest I could get to it, and it's, collateral talk about it.
So but it's a disjunctive clause. It's to prevent an immediate seizure, and I'm going to give Mr. Moulton a chance to respond in a minute.
Right.
I haven't heard him argue that.
Okay.
It was urgent and immediate necessity. Burger King seems to focus on the seizure rather than necessity, this fear that the easels might do something, and the court goes on to say, but they hadn't.
Right.
If they had done X, maybe. If they had done Y, maybe. But none of that happened, and so you were voluntarily paying that amount. Maybe the other case you handed me focuses on the first half of the disjunctive.
The first, I mean, as much as I looked for the first half, I didn't find it. Well, let's look at this next case, and then I'll address
Okay.
the facts we heard from the witness about whether or not they can shoehorn it into there.
Okay.
This particular case, again, it's a little complicated to follow, but essentially they were at closing. Okay. Well, first of all, the only part I highlighted in here, and I should have highlighted more, but it's just a procedural aspect, but I don't think Mr. Moulton challenges this, that Mr. Clarke has the burden of proving the voluntary payment statute applies. He's the moving party on this and's got to prove it. I just want to clear that. But this was a closing document. They're at closing, and the payoff is $105,000 for the mortgage. And the owner, and the seller says, I think there's some mistake in there. I don't think I owe that much. Right?
So the statute says payments of claims where all facts are known.
Right.
And here is a case where there is a debate about whether this was a proper assessment under the terms of the covenants, the POA. So why was Mr. Clarke, and frankly your client, why were they both not proceeding under some degree of uncertainty? I'll tell you, your co-counsel was unable to provide any example of this happening before, or any basis other than, it's a nice round number to say, we're going to assess the amount of rent that the homeowner decided his tenant ought to pay. And your co-counsel could not point me to any language in the articles that said that's the measure you ought to use. It seemed arbitrary, and arbitrary fines are certainly problematic. And so there's a dispute about that. And so it strikes me that all the facts here aren't known. Yes, we know the amount, but we don't know if that is an appropriate fine to begin with.
And so let's determine, because what you're talking about is uncertainty. And that, of course, is not what the statute says. The statute says not whether there's uncertainty about the outcome, but what do the parties know the facts? We're in the exact same position the Burger King parties were in, right? Not knowing whether or not a $4,000 monthly fee applies. They both know it's in the lease. One party says it doesn't for these reasons.
Not in the articles is anything that says that the POA can charge this random amount.
And he knows it. Well, the articles were there for them to know that fact.
But there's no fact. It doesn't say what the fine
No,
is.
the fact is that, that's a fact. They have the declaration, right? What you're arguing, and I hate to argue against you.
That's all right. This is new to me.
And what you're arguing is that we don't know the outcome. We don't know your decision, right? And let me take it back to this again. It's true. Until the court issued its ruling, Burger King, the tenant, could not be sure whether the court would agree on its interpretation. Is it an invalid fine for leasing?
Okay, I see.
However, the fact
I can read it. Yep.
Okay. Right, and then even the second highlighted part down there. So that's where I'm going at, right? We certainly had the substantial relevant facts about what's going on to make a decision, to make the payment, or to find another measure to handle this, right? And that's where I go to the fact, all we heard here was, I wanted the money. I didn't want another debt. Right? Nothing else. Nothing else. I mean, no alternative measure. I asked him whether or not he thought about getting a mortgage. And yeah, he had thought about getting a mortgage, but he just didn't want the added extra debt. I respect that decision, but that's still just a decision that doesn't eviscerate the statute. Right? There were other options, they say, bonding off, court registry, that was even in material. None of those were pursued. Instead of like at the Jackson, going back to the Jackson case, Your Honor, that was at closing. And in fact, they told me they thought it was a mistake. And then it reads, they were told by the closing attorney that they needed to go ahead and close and sell the deal and the sale and deal with that issue later. Right? And the court said, hey, sorry, you still closed and you went forward. Right. So, well, I don't know if you want me to bifurcate the argument and wait on the lost rent till you hear argument on this issue, or do you want me to move to the
No,
lost
you can
rent?
tell me about lost rent.
Okay. Now I forgot what lost rent was. Okay. Hang on a second, Yanni. So there's two other cases. They both stand for the same proposition.
Which ones are these?
These are the,
The Phoenix on Peachtree.
yes! Leon Grant and Saunders. Right. I just couldn't help using my case, Your Honor. But it's only for one of the issues dealt with there, right? And that's really a citation from the Supreme Court here, talking about HOAs when they delegate authority, discretion about either a violation, what makes a violation, what's the amount of fine, and that kind of stuff. And it's at the top of page 4. In the context of decision, and this is actually our Supreme Court in the Saunders case, in the context of decision-making by homeowners associations and condominium associations, our Supreme Court has held that, quote, whereas here the declaration delegates decision-making authority to a group, and that group acts, the only judicial issues are whether the exercise of that authority was procedurally fair and reasonable, and whether the substantive decision was in good faith, not arbitrary and capricious. So not whether or not you agree with the amount, but is it completely arbitrary or is it completely capricious? Right. Now, I'm not really here to argue the underlying amount of the rent fine right now. I don't believe that's at issue at this moment in this argument. What I bring up these two cases to point out was that the association put Mr. Clarke on notice of his tree trunk violation like 2 weeks after he rented the house. Okay, that letter saying you got a dead tree in your house, it needs to come down, right? The November 19th, 2018 letter, right? That tree doesn't come down until, the best we know, June 6th. I mean, I'm not, unfortunately, going to have any evidence to the contrary, although I had asked for it, but that didn't happen until that point in time, right? During that entire time, whether we like it or not, he's in violation of the declaration, right? Regardless of what the fine is. There's some amount of fine we know that's due, and we know that was never paid until closing. And then, as I said, I'm not going to harp on the $100 white rock issue, because I think that was also fixed around March 2020. The point is, that fine was never paid. And we even heard, so going to the testimony about this issue, we even heard he still doesn't know until he heard my opening statement what's required in the leasing provision. I mean, you got to be ready, willing, and able to provide a tenant before you can say, well, I'm just not going to do it because they said they wouldn't do it. And he never took the necessary steps on any of that stuff. But regardless, he's in
I hear you on
violation.
the first one, but the second one, you've also elicited testimony, as has Mr. Moulton, that Mr. Clarke had been told, you need to pay this fine, not the tree fine, not the white rocks, but the 15,000 plus fine, before you can try to release your property. So why would Mr. Clarke in vain proceed with any of the 12 steps or preconditions to release his property when he was either not in a position to pay the fine or was declining to? So I don't see Mr. Clarke telling you today, you know what, I didn't even know what all the steps were, because the full response would be, why would I worry about what all the steps are? I didn't have 15,000 to pay you, so it was clear to me I wasn't going to be able to lease this again until, and I intervened and said, actually, you need to put $5,000 into the registry, and then the POA is directed to consider a properly submitted lease. That wasn't in the cards for Mr. Clarke. What I heard was he wasn't able to put that in the registry. So
Let's set all that one aside, okay? I mean, I'll give you that to you here on testimony.
okay,
Right, and then you'll have to make a factual decision.
okay,
But setting all that aside, we don't have the payment of the white rocks. We don't have the payment of any fines on the tree stump. I mean, well, for $3,900, he didn't pay that at all. And he never came to us saying, hey, it should be lower, or here's the amount it should be calculated at $25 a day and pay that. He never paid that. And at least until June 6th, right, he was still in violation, right? But he remained delinquent after June 6th, setting aside the whole leasing issue.
okay, got it. Mr. Moulton.
So we are proceeding under this voluntary payment back that his property had been detained or seized from him, and that's why he made the payment. I mean, take a step back and look at it. Greystone is saying, and I think you have to take our version of the facts for purposes of this directed verdict motion, that the fine is unreasonable, that it's arbitrary and capricious, and that the case says, even under this standard that he wants to use, that the associations can do essentially whatever they want, it still has to be reasonable. He left that word out. It says arbitrary and capricious, but it also requires a showing of reasonableness. Must be procedurally fair and reasonable and made in good faith, and is reasonable and not arbitrary and capricious. And so if the fine is not reasonable, then it shouldn't exist. And the reason that he can't lease the property, therefore, doesn't exist. So Greystone is saying, we can impose unreasonable fines on you. We can then tell you you cannot lease your property to anyone else. And if you want to sell your property, the closing attorney is going to tell you got to pay us. And so you either sit there and do nothing, you rent it, you pay us, or you sell it and you pay us. And you just completely box the owner of the property in. And that is why I think it falls into the category of the property being detained, or to prevent immediate seizure of person or property. Well, they had seized it. They basically told him, you can't do anything without paying us $26,000. And I agree with Your Honor. I don't know if you point out that the Burger King case, nothing had happened yet in the Burger King case. They hadn't been threatened with eviction or evicted. But in our case, you know, it says in Burger King, however, the lease requires the Yeasels give Burger King 30 days notice of their intent to terminate, and they hadn't made that 30-day notice. But, you know, accordingly, there was no need to pay to avoid an immediate seizure of the property. Well, that's not what we have here. They had already seized his property. They'd already told him you can't lease it, and that if you sell it, you got to pay us. And so I think that he does fall into an exception, at least arguably, under this 13.113 voluntary payment statute. And then dovetailing with that on the lost rent, if Your Honor finds that Mr. Pastel is assuming that the trunk of the tree is a violation of the covenants. I mean, Mr. Clarke's response to the notice about the trunk of the tree and the car was to remove the car and to respond and say, I don't need to remove the tree, it's alive. And the picture shows it's alive. And
But let me pause you there. You've presented your evidence, and what I'm recalling, and maybe misremembering this, is that Mr. Clarke believes that the tree was still alive, and to call it a stump is really a misnomer. It's the trunk. But he did not relay to the board that he was resisting removing a non-dead tree.
That's not, I didn't put the email in. That was the one I said I'm trying to keep from overloading you. But he did testify orally that he informed them that he didn't need to remove the tree because it was not dead.
Okay.
They said, you need to remove the car and the dead tree. And he said, well, it's not dead, so I'm not removing it. And then it was only after that, long after that, actually, the fine for the dead tree was not imposed until April 27th. So to say that he was in a separate violation for the tree stump from August of 2019, when his tenant was gone and he would have re-rented the place had this issue not arose, through August of 27, the only real issue was the White Rocks, which was a $100 fine, and attorney's fees, and this $15,000 fine. So in our view, and as I said at the beginning, what kept him from releasing the property was this insistence that he pay every bit of rent that I don't even think he got that much rent, but that he could have received over that 10-month period to the association. And so if you were to find that that was a violation of the covenants, that they did not have the authority to do that under the covenants, or that it was unreasonable or arbitrary or capricious, then they breached the covenants. And that would expose them to damages for lost rent. And one other thing, the issue of the voluntary payment or not, if you were to find, okay, it's a voluntary payment, he can't ask for a refund, too bad, you shouldn't have done it. That doesn't mean that the claim for lost rent is lost. It seems to me they're completely separate issues. His breach of contract claim doesn't die because it may have been a voluntary payment. So, thank you, Judge.
All right. Mr. Pastel, can you respond, please, just to that last point about how you view voluntary payment doctrine having any effect, if at all, on the claim for lost rent? They seem, I don't think you connected them, and you agree they're not connected. You argued why lost rent shouldn't be collected because, and I'm summarizing, but Mr. Clarke was in violation of the declaration. He'd been put on notice that the stump needed to be removed, and until it was, that was a proper basis to deny. He hadn't paid those fines, hadn't paid the white, even though it's $100, he hadn't paid that. So there are markers out there that would make plain to someone who familiarized himself with the preconditions to leasing a property at Greystone that he wouldn't have been eligible to do so anyway, because of these outstanding known conditions.
I want to make sure I understand the question, but I'll say this, that his voluntary payment at the time of closing, in my mind, is separate from whether or not he can try to say, hey, I get to still.
Good. We're all on the same wavelength then. All right. I'm going to defer ruling on the motion for directed verdict. I would like to hear testimony from Ms. Harper or Ms. Rodriguez, and I'll work through the legal issues after I've heard that evidence.
So it'll be Ms. Rodriguez.
Okay.
Beth, are you unmuted? No.
Try again. We can't hear you.
Try your speaker setup. Make sure it's got your right speaker connected. You can do maybe a right click and drop down and see if it's. Is there a phone number for her to call into then too?
She's raising her hand. We see your hand raised, but we can't hear you. No. Try again.
While we're waiting for her, so you weren't the only judge subject to the Phoenix on Peachtree.
You spread the love around. I remember hearing about that case during our case.
Oh, did you? Okay.
Yeah, just because I think the other party in our case invoked that as an example of the mismanagement and how the chairman of the board
that's right.
rogue.
Right. You want to try now, Beth? I don't recall if there was a.
Ms. Rodriguez, you may want to just hang up and dial back. Maybe just starting a
You
whole
can
new
tell your
connection.
picture there and just call on your cell phone.
Or just this, I mean, as long as you've got the link, just leave the meeting and try coming back in.
I think that's what
We've
you
had
said.
success with that.
Okay.
All right. See what happens.
Can I be heard?
There you go.
Yes, much better. Thank you
Hey.
for dialing back in. You
Oh,
are.
thanks for the advice.
You
All
want me, you want me to do the honors?
Whenever you're ready.
All right, raise your right hand, Beth. You swear to
Okay,
tell swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Well, why don't you go ahead and tell us your full name and what you go by?
Yeah, my name is Beth Harper Rodriguez.
Okay. And you go by Beth Harper, correct?
Yeah, yes, I do.
Okay. How long have you lived at Greystone community?
I've been here for 22 years.
And how long, you're currently a board member, correct?
Correct.
Right. And how long have you been a board member?
Well, I was on the board 2 different times. I was on the board once from 2003 to 2004, and then from 2009 to current day.
So since 2009, you've been on the board.
Correct.
Okay. And I take it you're familiar with the HOA governing documents.
I am.
Right, I know you are, right. And of course, you're familiar with Mr. Leo Clarke's property at 1136, correct?
Yes, I'm familiar with it.
Right. And at the time of closing, we went through it. I'm just going to try to speed this part along real quickly.
Okay.
The closing letter was something you authorized, right? The $26,000 closing letter, Exhibit 26? Right.
Yes.
Right. And that comprised of the leasing fine for $15,500, the stump fine for $3,900, $100 white rock, and the balance being the legal fees, correct?
That's correct.
Okay, just wanted to kind of get that out of the way here now. Now,
Okay.
when and how did you learn that Mr. Clarke was renting his property?
Well, my fiance was doing a neighbor's lawn because he's a landscaper, and the tenant approached him to see if he could mow the lawn. So when my fiance came home and was telling me about it, I said, what property was this? And then when he told me 1136, I said, well, that's, at this point, we were calling him Alexander Tarlow. So that's when I found out.
Okay. And just again, to speed things up, we're already in evidence, but at that point, you sent him an email about it, correct?
Correct.
You sent him a letter on May 22nd about it, correct?
Correct. Yes,
And-
correct.
Right. In both that email and the letter, well, the email actually said, hey, the board wants to meet out with you, correct?
Correct.
And the letter itself actually said you have the right to meet with the board, correct?
Of course, always.
Right. Okay. And I don't know if it's worth belaboring, but eventually everybody gets caught up and is able to do the meeting on November 17th, correct?
That's correct. Yes. Mhm.
Okay. Now, in your recollection, who was present at the meeting on November 17th?
All 5 board members would be myself, Kendra McLeod, Christine Kinsell, Melanie Jackson, and Deborah Hobbs, as well as Mr. Clarke and his wife.
Okay, so that was Sunday, November 17th.
That's correct.
Okay. So can you tell us what was discussed with him about the leasing situation?
Of course. Mr. Clarke came in and he was saying that he didn't know that there was a leasing amendment. We talked about that for a little bit. He went on to state that, he had to evict the tenant. The tenant had destroyed his property. He paid thousands of dollars to have it renovated. And he was paying a mortgage on that property. He didn't mention owning another property, and stated that he was experiencing a hardship and that he could not pay $15,000. So we said to him, our goal isn't necessarily just to find people, it's for compliance. So we said to him, as he was telling us all the things he had to do, he had to evict the tenant. So I said, okay, listen, I've asked you before to give us a copy of the lease because he told us his rent was $12.50. But then we would later find out it's really $15.50. So, but I said, can we have a copy of your lease? And I said, and also, if you could get us a copy of your court documents where you had to evict this tenant, and we can significantly reduce your fines, and we can work with you. And I said, but we do at least at minimum need to have a copy of your lease.
Why
And
do you need the
that's-
lease? Why?
Well, I'm sorry.
No, I'm just curious. There's this fixation on getting the lease. I mean, why?
Yes, because in our leasing amendment, that is one of the things that it states. We don't pick out tenants for anybody, but one of the things that it says is that after you have found your tenant and you screen them through the process, that within 7 days, you at least allow us to know that you've rented, and then also within a 10-day period, provide us with a copy of the lease. So it's
Well,
just.
I get it. I get it if it was still an active lease. That makes a ton of sense. And I think the requirements, if followed, make sense. But I'm curious why in Mr. Clarke's case, it was a big
Gotcha.
hang up for the board to get a copy of a lease that really didn't matter anymore because the tenant was gone.
I'll tell you, I understand now, I apologize, because I was questioning the validity of the amount of money he was charging. And I wanted to be able to compare it with what he verbalized to us as $1,250 to what was actually on the lease itself. And then, like I said, later to find out that it wasn't the correct amount, it was $300 difference.
So next question on that. The fine ended up being 10 months of the rent in the lease, which was $1,550. But it sounds like as of November 17th, you already knew what the fine was, $15,500, which means you already knew what the rent was, $1,550, and yet you didn't have a copy of the lease. So help me balance out your claim that Mr. Clarke had told you $1,250, and you only learned when you got a copy of the lease that it was $1,550, but you already came up with a fine that, according to what the lawyers have always represented, I'm only meeting you for the first time, Ms. Harper, but the lawyers for the POA have always said the fine was based on the rent was $1,550, and yet no one ever had a copy of the lease. So I'm confused.
Yeah, well, to the best of my recollection, because I don't keep the books and records, but to the best of my recollection, however that was deemed, I think we also had a different time period. And so we weren't really sure as to when it actually started. All of this documentation that we're talking about now is in hindsight where we have more facts. But at that time, it wasn't all that clear. And it may have also included some of the fines that he had incurred for regular violations as well. Because on his letter,
Well, you muted by accident.
encapsulated just the lease.
Right.
That's what I can recall.
Thank you.
Okay, sure.
Did the board ever tell Mr. Clarke at that meeting that under no uncertain terms could he rent until he paid the full fine?
No, when we were leaving and concluding the meeting, it was established that he was going to get us a copy of the lease, and he was going to get us a copy of the eviction proceeding so that we could reduce it so that he could become in compliance and he could rent his property, because he said he wanted to rent his property. So we were like, okay.
Right.
So that's how that.
Right. And then,
Can I say something? And then the next day we received an email from the wife, and that's why I said it was a nice meeting, which meant that she felt comfortable enough to say, hey, we can't find the lease, right? But we want to offer $1,000, which isn't what we discussed. And so that's when I said that wouldn't suffice. And so that's how that was, because they understood. And then we didn't hear from them again until they got an attorney.
and that's where I was going, that email the following day, when you're talking about that's not sufficing, you're talking about reducing the fines to just $1,000.
Exactly.
Right, because he had rented it for some 10 months, right?
Right. Yep.
Right. At any point after that email, well, did you have any further communications with Mr. Clarke? Well, did the board have any further communications with Mr. Clarke regarding the leasing and his ability to either lease again or to reduce the amount of the fines?
No, we didn't talk with him again. And then, no.
Okay.
Neither him or his wife, actually. Yeah.
So there's that one board meeting, the one email exchange, and that's it about the lease.
That's correct, except for the email that I got from them on the
That's
18th, and then I responded. Yeah.
Board meeting, right, and the thing. Okay.
Yeah.
Now, setting the fine at the amount of the rent. Right? Can you articulate why that's a reasonable thing for a board to do, your position?
Yes, sure. When we first had the leasing amendment done, our attorneys was Lozega and Johansson. And Lozega and Johansson put in the leasing amendment some verbiage that talks about liability for assessments. And the liability assessments is equal to 1 month's rent. And how it was explained to us is that if you have somebody who is renting their property for $1,500 and your fine is only $25 a day, then the fine for the month is only going to be $750, and therefore it would not put it wouldn't be a true penalty because they would still benefit. That's how it was explained to us.
Right. In other words, at $25 a day for 30 days, that's $750 a month, right? If you're leasing for twice that price, what the heck, right?
Well, yeah, because then there you go.
Right. And certainly, this was not an arbitrary number because it was set at a specific amount, the amount of the rent, correct?
That's correct, right.
Right. And it's certainly not a capricious number because, again, it's a precise calculated number.
That's right. Mm-hmm.
Right.
Ms. Harper, how many times before Mr. Clarke's situation had the board assessed a fine of the amount of rent on someone who didn't comply with the leasing requirements?
Well, actually, I can think of one that comes off the top of my head. We had a property that was purchased by an investor. And this is one of the reasons why we even started the leasing amendment, because when the when the housing was going down, we had a lot of investors coming in, buying foreclosed properties and trying to rent them out. So we had, it was a investor, and they had purchased the property at 954, put a tenant in there. And that's when we did that. And then, they were a business, they couldn't say that they had a hardship because you have to have been the primary homeowner in the property for 2 years prior to being able to rent and be in good standing. So they ended up getting rid of the tenant and paying the fine. And the fine was 1 month's rent, for however long it was there, might have been 3 months.
Okay, and it was the rent that homeowner charged that tenant?
That's correct. Yes.
And the situation you described occurred before Mr. Clarke's situation?
Oh, yes. Mr. Clarke didn't rent his property till 2018. This would have happened like around 2014 or so. Mm-hmm.
Is there any reason the board didn't seek to memorialize this? The covenants or the bylaws talk about some fine amounts. There's nothing in there. It doesn't sound like it would be difficult to make it clear. Hey, if you don't lease this out the right way, we're going to claw back all the rent that you earn.
Exactly. And we can do that. And that's great. What I was told was that we have, I don't know, I'm sure they gave you a copy of the corrected amendment to the declaration for the leasing amendment, but there's also a page that says lease terms exhibit to the amendment, and it's section B, liability for assessments. And on that, it states how you can go about getting benefit, or if you have a homeowner who is delinquent in assessments or any other charge, okay, that you can actually charge the tenant the cost of the rent to pay it to the association until all the assessments or back assessments that would have been owed are due. And you can also treat the tenant as if the tenant was the owner. And then if the tenant doesn't comply, which of course puts the tenant in a bad position because they're looking to pay their rent, they don't want to be evicted. But then the association also has the ability to evict that tenant, which we've never done.
Thank you.
Let's see here. I guess we'll move on to the tree violation.
Okay.
Right. I mean, your first notice out to him was that he has a dead tree in his property.
Yes.
Can you describe to the court what that tree looked like?
Well, it was like a regular, I don't know trees, guys, but it was just like a regular tree. It was overgrown. He was asked to trim them back. In his attempt, and I'm assuming it's him because he said it was him, right? That whatever he did to it, there was not even a branch left. It was just a log,
Right.
that just, and then eventually started springing up something on the top, like a toupee, if you will, but there wasn't a viable looking, tree. So we're like, this is unsightly, unfortunately, this is what it looks like. So can you please handle it and take care of it?
For lack of a better expression, are there any other homes in the community that have a stump tree?
Yes, we actually had another homeowner who had something similar. They hired a landscaper, they butchered their tree. It was no longer viable, no longer had branches or was flourishing. And we asked them to remove it and they did.
Okay, so the only other time there's been a stump tree, you've had them remove it, correct?
Oh, yeah. We don't ask anybody to remove a living tree.
No, but I just want to make sure the court knows that if I were to drive through the community now, I wouldn't see other homes with stump trees and they're not getting, right. Okay, right. Let's talk about the ring around the tree, right?
Okay.
And the mulch in there, right? If I were to drive through the community, am I going to find just random rings with mulch in them?
No, that's just neglect. Yeah, he just forgot to take off the bricks and, maybe lay some sod down and, anybody who would, it's the front of your house. Mm-hmm.
Right. But I want to make sure that's not the standard of the community.
It is not the standard now.
Right. And the white rocks, he didn't contest about arguing and moving. But he was fined $100 for the white rocks, correct?
Oh, yeah. Mm-hmm.
Right. And he never paid them.
And let me, I'm sorry, Mr. Pastel,
Sure.
Let me just also interject. The board has we send out every spring a reminder to all homeowners, hey, it's time, let's get things spruced up. We remind them of little things that you're not supposed to have due to our design guidelines. And that's always been there,
Right.
And not only that, but Mr. Tarlow used to stop in over at the clubhouse frequently when he would get letters to get understanding. We always talked to him. Yeah.
Right. So, but he did remove the rocks of it, right? But he never.
Yeah.
My point I'm getting to though is that from your books and records, you never received the $100 fine until he sold the house. At the closing.
Yeah, we never received it. Yeah, we never received anything. And if I might say this to the court, I just want to make sure that the judge understands that at no given point did the board was not willing to work with Mr. Clarke. We offered him a deal. We were going to bring it down to like $3,000, if he could bring us these things so that he could get himself corrected. And then again, I believe with his attorney, there was another amount. It was like, I think it was like $700 to $800 that we were willing to do that I believe Mr. Clarke accepted. And then the next day said no. So he wasn't willing to do anything to help his situation.
Who would have conveyed to whom this first offer you said that for $3,000 or $3,500, we'll just wipe the slate clean and move forward? Would that be you communicating to Mr. Clarke? Is that Mr. Pastel?
Yes. No, that was us. We were at a board meeting with the 5 board members and Mr. Clarke and his wife. And we just said to them what we needed. Lease, show us the eviction. We understand you had to pay $1,000. We understand that your property was destroyed. We understand that you have a mortgage to pay at 1136. And also, just to make everything clear, when we spoke to him and asked him for his address, he never said he purchased another property. He said he was staying somewhere with his wife. It made it seem like it was like a family member or something like that. It was never clear cut. And then that was it.
So just, I want to pin this down. So you're saying at the November 17th meeting, because it sounds like that was the only meeting. At the November 17th meeting, you or someone on the board or the board collectively offered up a settlement amount of $3,500.
It was $3,000. It was between like 3 and 4-ish, not over that. And we were going to offer that if he could provide us with those things to make sure that the tenant was evicted, to make sure that actually happened. Because when we asked Mr. Clarke, he said he didn't know who the tenant was. He didn't pick the tenant, didn't know the tenant's name, nor did he know how to get in touch with the tenant.
But I just want to make sure that this figure, whatever it was was something that you conveyed, or it was something you were prepared to convey if Mr. Clarke and his wife looked like they wanted to negotiate? Because there's a big
Yeah.
difference.
Right, I understand. I communicated it to him directly, right
Okay.
there in the room with everybody, and asked for those things, which is why the wife responded the next day saying she couldn't find the contract, but then came in with a lower offer, which I thought wasn't a good thing to do,
Well, let me also ask you back on this wanting to have a copy of the lease issue. Right?
Okay.
You had just had a stranger living in the community for 10 months, correct?
Not only
Right,
was
that's
he a
tenant.
yeah,
Right. Even
Yeah.
if we take Mr. Clarke's word at it, right? No idea who this person was, unless you have the lease, you won't have their name or phone number.
wouldn't have a name or phone number or anything like that, right?
Right.
And
True.
also, even if you didn't see the leasing amendment in the actual declaration, which is like 20 or 30 years old, right? There's still a provision about if you leave. If you're leaving and you want to rent your property, you still have to provide us with your physical address and, so we can keep in touch with you, as well as the name of in your information. So that was always standard.
Right. So even when, I think if I just heard your testimony correct, the day he moved out of the community, he was in violation by not giving the association a forwarding address.
Oh, exactly. Yes, exactly. Mhm.
Okay. Just, I think 2 more points to button down here. One,
Okay.
under your governing document, right, fines are considered assessments, correct?
That's correct.
Right. Even though it's a different kind, it's not your regular annual assessment, but it is an assessment, right?
Yeah,
Okay. And then you did hire me, right?
of course.
In fact, I think I've been doing work for you for about 13 years or so, right?
That's right. Yep.
Right. And you've paid my legal fees for representing you here, correct?
That's right. Mhm.
Okay. Well, Mr. Moulton?
Mr. Moulton, questions for Ms. Harper?
Is it okay if I just sit here?
As long as she can hear you, you are welcome to sit right there. I can hear you.
And can she see the exhibits if you put them on the screen?
We'll find out. She should be able to.
Can you hear me, Ms. Harper?
I can hear you fine. I'm nervous about changing my screen. I don't want to lose anybody. But
I don't think you have to change any screen. Let's try it out. What do you want me to share?
Well, let me start out by asking this. The board did not incur any kind of attorney's fees to collect the annual dues from Mr. Clarke, did it?
No.
Okay. All of the attorney's fees have been to collect the fine for the lease, the White Rocks, and the stump, correct?
That's correct for his violations, yes.
Okay. And the fines, for instance, I think the tree stump fine is $25 a day. Is that something that is published and somebody could come and see how much it's going to cost me per day if I don't cut down a tree that is demanded of me, or a tree stump?
When we send, when a courtesy letter is first submitted or sent out to the homeowner, it states, hey, this is the issue. This is what was noticed. These are the infractions. And we require you to cure within 10 days or contact us, give us a reasonable amount of time. And if you fail to do that, then a $25 a day per day fine will be incurred.
And is it always $25 a day?
Only for certain types of things. For example, when the board send out emails, well, I didn't mean to say emails, so we used to have, but I won't get into that. All right, so when we send out regular letters and reminders to homeowners, it will state, if you do not submit an ARC form for any exterior improvements, it could cost you $100, depending upon what it is. Is it a roof that you put on, or is it just that you painted your shutter? So we are always communicating with the community regularly. Flyers, everything. And like I said, Mr. Charlie used to come in and talk to us all the time. So, yeah.
So the architectural fine is $100? for a violation?
No, only if you don't submit an ARC form, an architectural form, because you could incur a lot of expense if you don't get approval and you have to remove it. So it's to deter people from doing that so that they can get approval before, spending their money on expensive things.
So that $100 fine, for instance, who determines that?
We determined it as a board. We adopted that as something that we were going to implement, and then we communicated that to the community.
So you determine the fine in each case before you send the letter?
No, sir, not in each case. A regular violation fine, if you haven't had remember, ARC fine is different. ARC is I'm going to do an outside improvement. So if you're if the regular drive-through has happened and you have, your shutters are hanging off or you haven't, painted something, it's a $25 per day, but collectively, it's not per instance, it's for any violation, whether it's 1 or 4.
Okay. And the White Rock fine, was that for 4 days, or how was the $100 determined?
No, that was for not submitting an ARC form. We also sent out to everybody a style guide, which is a design guide that the board implemented years ago. And the one that I knew about was in 2009. And in that it says under the landscaping area that anything that you are to be doing landscaping, with the exception of replacing some shrubbery, that you have to submit an ARC form, no matter what, rocks or anything.
So it wasn't a fine for white rocks. It was a fine because he didn't ask permission to put white rocks out first.
Well, exactly. He would have to have asked that, and he didn't.
Okay. And you're saying that there are architectural guidelines that would prohibit him putting white rocks around the post of his mailbox?
There is a guideline stating that the board has the discretion to be able to make that determination. And we have made that determination and have produced a style guide for design guidelines for the homeowners to be able to follow. They can, of course, submit an ARC form requesting different material. And, we look at it, we don't try to stranglehold people. If they come up with something and we might say, okay, sure, go for it.
Okay. And you're saying that he had to get permission in advance to put white rocks around the base of his mailbox, just to be clear, correct?
Yes, because they were rocks, yes.
So if it was some kind of bush or plant, he wouldn't have needed permission.
Well, it depends. If it was just like a perennial or a small shrub, but it's all delineated in our guidelines, our style guidelines.
Okay.
And
Now,
like I said, he's asked before about things, and we've always told him. I think everybody in here is ad nauseum with all of our reminders.
Now, you say that you were advised that fines for lease violations needed to be the total amount of the rent charged to the tenant.
Yes, and the reason for that, like I mentioned before, is that the attorney explained to us that if you were only to do a $25 a day fine, and let's say that their rent was $1,800, they would have benefited from, $1,100 or what have you, so that's what it is, as well as in the area that I mentioned for the liability for assessments, with it stating that it would be the tenant would pay the amount of rent until any of the delinquent amounts are paid off. In other words.
And so you say it's not a sufficient penalty just to fine them $25 a day. I think those were your words, right?
Right, because if you have a property that is $1,500 and you would have still benefited from making $750 and paying $750, there might not be a consequence for you to enter into compliance.
Well, it would be a consequence of $750 a month to you. You do realize that, right?
Well, I do realize it, but you didn't have to have a consequence at all. If you would just submit the proper documentation and get approval, everything would be fine.
Are there any records kept when the board debates how much a fine should be?
Yes, whenever we make them, we don't adopt much. Like I said, this was something that we did in 2010. So we would have it in our minutes.
Well, what I'm asking is, are there minutes from your discussion of how much to fine Mr. Clarke?
No, because it was already noted. We already knew how we were going to find him, as we have done in the past with others.
So it was in 2010, Ms. Harper, that the board got the advice or decided to follow the advice from the Lazega and Johansson attorneys that the fine for renting out a property without permission or authorization, the fine ought to equal the rent. Is that what you're saying happened in 2010?
That's correct.
Okay.
You remember when I asked for documents from your organization?
I don't really recall. What I do recall is I got an email from you stating that you had sent me a letter. I told you I didn't receive it, but you were saying that you were our client, you know, Mr. Tarlew. Well, I'm sorry. I know we're using his name exchangeably, so I'll say Mr. Clarke's attorney. And at that point, I told you that, you know, anytime an attorney, you know, comes into play, we refer him to our association's attorneys.
Okay. So based on what you've said, it sounds like the board has the discretion to change the fines.
Again, like I said, it's not that we have the discretion just to change the fines. It needs to make sense. What we do is it's $25 a day for regular, everyday drive-through issues. For the leasing amendment, it came across that figure due to the fact that it was.
I get that, but.
Oh, okay. Well, that's why. Well, we don't just come up. It's not picked up out of the air. You know, there's a certain criteria that we use with everyone.
But
you know, I will also, go ahead. I'm sorry.
Well, you say that at the meeting on November 17th, you decided to reduce the fine to somewhere between $3,000 and $4,000.
That's correct. And we always work with our homeowners, always. Our goal is not to create a problem. Our goal is to gain compliance. We haven't had any issues, you know, with Mr. Clarke. We've always worked with him all the time. So when we never heard from him after November 18th, and then we saw you, that was a little shocking, but you know, it's okay.
But so when you can change the fine from $15,500 to $3,000 to $4,000, that means that you can change the fines, right? I know you call it working with the homeowner, but what you're doing is reducing the fine.
That's right. We reduce the fines to make it something that's more amenable. If the client is willing to be amenable, most certainly.
All right.
And they said they were going to go home and look for those items, and then they were going to get us the information from the court for the eviction. And we said, fabulous. We'll hear from you when you get it. We didn't give them even a time. You know, it was getting ready to be the holidays. But like I said, then we got an email from, you know, Mrs. Clarke, and we were like, oh, where'd this come from? And then that was it. And then we had you.
Right. So after the meeting on the 17th, you got a follow-up email from Mr. Clarke's wife, right?
The next day, yes.
And that's Exhibit 11, Judge. Maybe you could show her that.
Let's see.
You seen Exhibit 11 there?
Hold on, let me just make it bigger. All right, it's an email, December 9th. Oh, yes, I remember this.
So this is after the meeting
Uh-huh.
at which you just testified. You told Mr. Clarke the fine could be reduced to between $3,000 and $4,000, right?
Yep. Yes.
My client sent this email, or his wife, or actually he sent this. It said he couldn't find the lease, and
Right.
that he wanted to pay $1,000. Right?
That's what. Uh-huh.
Now your response is about 3 weeks later, December 7th.
Yes, it was a holidays. Uh-huh.
So it's after Thanksgiving. So
Yes.
in this, you said that you have to have the lease and you have to have proof of the eviction, right?
That was what we agreed to at our meeting on the 17th, yeah.
And it says nothing in here about your agreement or willingness to reduce the fine, does
No,
it?
what it does say is that we would not be able to give them the consideration, and the consideration is what we talked about on the 17th. We needed those items. Those were the things that we asked for. They wanted to say, no, we don't want to give you anything, no eviction information, no leasing information. We just want to give you the $1,000 that would normally be charged for a leasing fee. And we didn't feel that that was fair or just.
But you'll agree with me, no reduced figure is mentioned in your email on Exhibit 11, won't you?
I'm sure. I mean, it was pretty informal. It wasn't anything formal like our meeting that we had. Mhm.
All right. And Judge, if you could show her Exhibit 12. Have you seen this letter before, Ms. Harper?
Hold on one second. I'm going to wait for it to go up so I can press on it. Give me one moment. Hold on. Yes, this is the one that I said that I saw in February sometime when you told me that I hadn't responded, and I said, oh, I apologize, I didn't receive that letter, but thank you for providing it. And then that's when I mentioned to you that, you know, in cases where people get attorneys, you know, we send them off to our attorneys.
Right.
Because I'm not an attorney.
And you emailed me back, right, in February.
Yes, in February, sure.
And in your email back to me, I also made an offer to pay $1,000, or actually $1,000 application along with a fine, and suggested that the White Rock fee didn't seem right, and was trying to, I asked you to help me work towards an amicable resolution of this, right?
Yes, sir. And what I said was, when
You told me to
just-
talk to Mr. Pastel.
Don't interrupt her
That's
when
right.
she's in.
But we need to be clear here, and so everybody can understand. Your letter was dated December 12th. I didn't receive it. I didn't get it. So when you emailed me in February is when I, with a copy of this, I said, oh, thank you for sending it. And then I said, you go on to Mr. Pastel. So any negotiations at this point, I didn't know that Mr. Tarlew had retained an attorney.
Ms.
At that
Harper,
point,
the address of P.O. Box 388 in Lithonia, is that a correct address to get things to you?
It is. It is a correct address, and you have a volunteer board, and sometimes when people go and get the mail or whoever gets it, they might bring it to the clubhouse, but I didn't receive it.
Okay.
Or I would have sent it to our lawyer in December.
Now, Exhibit 13, Judge, I apologize. In the meantime, the board sent another letter to Mr. Clarke. It's Exhibit 13, dated January 20th.
Okay.
You remember this letter?
Well, I didn't send it, and I looked at it because it was an exhibit. So I saw it, and that's when I was like, okay,
This is an authorized letter from the board, right?
yes.
And the board is the one that had talked about reducing the fine to what, a fifth of what it was on the ledger?
Yes, we told him it would be significantly reduced between
Right.
3,000 and 4,000 if he provided us those documents.
This letter here, notification of continued fines, tells Mr. Clarke that no lease was provided, no permission to lease given to owner. Because of this, the fine is the amount of rent will be charged the owner's ledger. See that on number 1 there?
I sure do.
You would agree with me, there's no indication here that the board is reducing the fine or negotiating this, is there?
This is what this is stating is a regurgitation of what was owed initially. Okay, and that we had not heard from them since that time of after November 18th. And so therefore, as far as we're concerned, it's they don't want to, they weren't interested in that deal, which clearly they weren't. They came to you.
And my letter that I sent in December, you didn't get for some reason until February.
Right, that's what I told you, and I explained that to you in your email in February. And I thanked you for it. I read it, I saw it, and I said that we would send it over to Mr. Pastel immediately so that you all could communicate.
And then did I hear you testify later that you actually agreed to reduce the fine to $1,000?
Never.
Okay. But you said that you told your attorney to agree to 7,000 and something. Is that right?
Yes, we were always willing to negotiate, always. And then we heard that Mr. Clarke agreed. And then the next day he didn't agree. I mean, this is just it's just the history. You know, you meet, you offer, they go. I mean, we just don't know what to say.
Now, you've seen Mr. Pastel's letter in which he informs me that the fine was based on a rent of $1,250 a month for 12 months.
That's what I was told that the amount of rent from Mr. Clarke was, you know, and then, like I said, we learned later it was really $1,550.
But the 1,250 times 12 is 15,000. If you'll take my word for it.
I do. I take your word for it.
But in August, you entered a fine in the ledger of 15,500.
Now, keep in mind, we would have been charging for the year because we didn't understand the dynamics. We did understand that his was not good because we had to have the police go over there and everything. And actually, during the term of the lease that we didn't know was being leased, we had letters sent to Mr. Tarlew of violations, like cars hanging off, and at no point in time did he ever say, oh, that's my tenant. You know, he just said, oh, I'm not home. You know, I'm not home. Even when I spoke to him in March, trying to ask him if he would vote for the board, the 3 members that were running, he told me he was on the road, wouldn't be back until April, and at no point told me that he wasn't living there.
Did he tell you he didn't want to vote for you?
No, it wasn't for me. It was for Christine, Kendra, and Deborah, and he said he would. He just said he was not able to pull over or print anything because he was on the road. That's what he said. So I just said, no pressure, you know, and I have the emails. I said, no pressure, you know, good day, you know, and that's it. But at no point did he ever say, oh, I'm not living there. Because I think at one point I said, hey, can I go by there? I guess it looks like somebody's home. Maybe they could sign. No. I said, okay. He said, I'm not home. I said, all right. Didn't know he didn't live there.
You testified, I thought I understood that Mr. Clarke gave you his new address. And you
Mr.
took that
Clarke gave
down?
us something. Yeah, he gave us something. And I don't know that anybody actually really had it because it was obtruse. We were in the room and he wasn't, we're like, well, where are you living now? Well, my wife's living over here. We're like, okay, well, are you living with your wife? It was like pulling teeth, but he never said, oh, this is where we live. We bought a new home. We're no longer there. But whatever he gave, I didn't write it down. I didn't have it.
Did anybody on the board write it down?
I don't know.
Okay. This tree that's at issue, the log, you're saying that started with the board asking Mr. Clarke to prune the tree?
Trim the branches that were hanging over into the street. Mm-hmm.
And then when he did that, you thought he had gone too far, right?
Yeah.
And but you don't disagree that the tree is still alive, do you? You said that it's grown a toupee.
Sir, I am not an arborist, all right? But clearly, it didn't even have a branch.
It had green leaves on it. Didn't it have green leaves?
It eventually had green leaves. It didn't have green leaves when it was first butchered. And we didn't know that he did that. He could have hired somebody we didn't know.
The first case you mentioned where somebody had violated a leasing provision years ago.
Yeah.
You said that was an investor and the tenant was there for 3 months, right?
Yeah, 3 or 4 months. And we let them know, hey, investors, you know, you're not eligible to rent or to lease your property. You haven't lived there as your principal address for 2 years. And then they were like, oh, well, you know, we bought this and, you know, you're not even in the definition of hardship, you know, because you're a company, you purchased this property and you can't rent it.
But
So, and that was one of the reasons why we initiated the leasing amendment, was we had so many investors buying, people who unfortunately were losing their homes due to foreclosure during to the economic slump. And we just couldn't do that because it would affect our, sale values.
did I understand you to testify that you reduced the fine, or the fine ended up in that case being 1 month's rent?
No, I don't know where you got that from. What I said is that what it ended up being was the 3 months that whatever they were in there. And I think that's what we did. I can't recollect, but they were charged the monthly rate for whatever that was for the period that it was.
Do you have any records of at all, minutes, emails, letters, anything like that, that tells Mr. Clarke and his wife that you're prepared to reduce the fine in this case to $3,000 to $4,000?
Well, I'm sure we do. I'm sure we have something in there that would have delineated the information regarding the meeting that we had. And again, like I said, that's why the wife, it was not a hostile meeting. She felt comfortable. She sent an email the next day. Hey, couldn't find it, but this and this and this. It was a good meeting. It wasn't even a bad meeting at all.
I subpoenaed from the association all the minutes that refer to Mr. Clarke and his property to be brought to
Okay.
court today. And I believe your lawyer has produced all the documents that meet that description. And there are no minutes in court today about Mr. Clarke at all, not one.
Oh, well, but like I said, to my recollection, we had a secretary. She's no longer on the board. Her name was Deborah Hobbs. And she would normally write down the things that we discussed. But that's what we discussed. And again, that's why I said when Mrs. Clarke's emailed us, she emailed with a lower amount, probably thinking, well, if they'll go to 3 to 4, they may go to 1. Because you don't go from 15 to 1. So clearly, anyone hearing this testimony or understanding the dynamics would believe that somebody wouldn't just come back with that, because that would just be ridiculous.
No further questions.
Okay.
Mr. Pastel, any follow-up with Ms. Harper?
No, Your Honor.
All right. Ms. Harper, thank you so much for connecting. You're free to stay on if you
Okay.
want to. You just can ask you to mute again.
I think I can do that. Okay.
Great.
Bye, everybody. Okay.
Mr. Pastel, any other witnesses besides yourself?
No, Your Honor.
Okay. And do you have any testimony that is unrelated to legal fees?
Well, yes. I mean,
Then let's do that.
basically, Your Honor, again, let's see, I became barred in 1991, starting in 1995 or 6. I became employed at the law firm of Becker and Polikoff. They were located down in Florida. They were a 100-attorney law firm. They had over 4,000 community associations. As far as my research shows, I think they were the largest community association law firm in the world. I became a partner there. Then after moving up here, I started my own firm with a group of other people. We continued the community association practice as one of our primary things. We also did construction law, which I did at both law firms, which includes construction liens and those sort of items here. What I want to testify is about the various options that Mr. Clarke could have pursued instead of selling his house to free up the equity in the house.
So you preface that by sharing with me the dozens of years you have spent becoming an expert, uniquely qualified to know all the options. Why don't you start by letting me know why you think Mr. Clarke would have known about any of the other options?
That's, there's no, I don't,
Okay.
my responsibility, whether he knows or not.
No, but
Whether
if you
those
are,
responsibilities exist.
well, or whether they're commonly known. If you're going to share with me an exotic way that something could have happened.
I'm not going to show you an exotic way, and that's
Okay.
why I'm not even sure, all this pomp and circumstances as needed, but I just wanted to
Okay,
clear any hurdle that we might have.
I think you've cleared it.
I've mentioned them in the opening. I mean, court registry is not an exotic thing. In fact, that was laying on his desk with the TRO order,
Yeah.
the option to do a court registry. Right? Transferring liens to bond, I do, not all the time for construction companies, but we do it regularly, right? We do, when there's monetary judgments and it's on an appeal and that kind of stuff, and it might affect property, so transferring this lien, and that was my point about fines being assessments. It's a lien on the property, right? He could transfer that to a bond, and that clears it completely. It's really not a buyer's option to get out once it's transferred to bond. Escrowing the money, I've done lots of escrowing the monies of construction liens, especially in condominiums where one unit's selling, and we have a lien on the entire condominium. And I don't think I have to be an attorney to talk about mortgages or HELOCs, home equity line of credit.
But those last two, certainly options. They would have been options to get it paid, maybe it almost in tandem. You could take the HELOC or the mortgage to get the money to put it in the registry. Because of course, if they took out a mortgage.
No. He doesn't need to sell the house. He could have kept the house for his kids. He needed some money. That's what he's claiming he did. The house is detained because it can't be rent, the equity in the house.
But if he took a mortgage out to pay the 15 grand.
No, he doesn't pay the 15 grand. He takes the mortgage out. Now he's got $200,000. The equities in the home is free. He can do what he wants.
Okay. But how does that resolve the?
None of these resolve it. That's the whole point. None of those 5 options resolve it. It keeps him from having voluntarily paid it.
Well, I get that for 1, 2, and 3. He can still sell it and he won't have voluntarily paid it. But the other 2 involve taking on debt.
Yes.
Okay.
But in other words, Mr. Clarke got emotional about having to sell the house, right? 1, 2, and 3 involve still selling the house to free up the equity in it, right? The other 2 options that were available to him, he could have kept the house.
Okay. But 4 and 5 alone don't address the fine. 1, 2, and 3. I know I'm putting numbers.
The 1, 2, and 3 don't address the fines with me either. They only address the fines between the buyer and seller.
Agreed. But then at least there's money put aside somewhere, and then Mr. Clarke could continue to litigate the reasonableness, the arbitrariness, et cetera. But with 4 or 5, if he paid off the fines after he got the mortgage or the HELOC, voluntary payment still may
Absolutely.
undercut him.
Absolutely.
Okay.
That's why if he got a mortgage, he would not have paid off the fines.
Okay.
Right. He would have just had the money.
Okay.
He's trying to circumvent the voluntary payment statute by saying I didn't have access to the equity in my home. That's how I've read the complaint.
Oh, okay. I understood it differently. It was, I've got this asset sitting there that I can't do anything with. I have it to make some money, not to borrow off of. And I can't make money off it if I can't lease it. And if I can't lease it, then I'm going to sell it.
Well,
And so his rock and a hard place was this dead asset, unproductive to me. I don't think I should pay 15 grand. He did end up paying it. And so he needs to navigate the tricky waters of voluntary payment. I see 1, 2, and 3 as ways that the closing could have gone through
sure.
without having made the voluntary payment. 4 and 5, I'm understanding you. I understand the words you're saying. I don't think that addressed what I understood Mr. Clarke's needs to be.
Okay. If you're going on just his selling it to get another productive asset, which I don't think falls into one of the needs of the voluntary.
May not. I agree, and that's a different argument.
But again, to his thing about wanting to keep the house, 4 and 5 allow him to do that.
Okay.
Then the other thing I wanted to testify about was the time it takes to get a foreclosure. And again, just because I've walked through so many of them in our court system here in the last 10 years.
Well, let me, before you have to go through that, Mr. Moulton, you don't, I haven't heard you argue this. I don't expect you will. Your argument is not, my gosh, the urgent and immediate need that Mr. Clarke had was that with a flash and the snap of the fingers, his property could have been taken from him. I've heard you argue already. You said it was effectively seized because he couldn't rent it. And that's got the merit that it's got, but I have not heard you say that your client was in imminent, as in within a matter of hours or days, it could have been foreclosed upon. Had someone tried to foreclose on those liens, it would have necessarily taken weeks and weeks and weeks and months, and there could have been litigation pursued that might have thwarted the foreclosure. You agree with that?
I agree. All I would say about that is that when he got the answer and the counterclaim, and it said one of the counts is for foreclosure. I mean, I didn't ask him this in his testimony, but I think anyone would realize that's
I got it.
frightening at best.
All right. I will take judicial notice of the fact that foreclosures do not happen instantaneously.
And then I did have one piece of evidence. Although it's already, I guess it's already in. So what I'm looking for, Your Honor, and I'll testify to it, I don't know if there'll be any objection to it. On January 3rd, 2021, 10 days before the closing, I sent an email to Mr. Moulton advising him that the association was going to have to issue a closing letter on the property.
Okay.
I just wanted to get that on the table, that we weren't trying to hide any games for it to pop up at closing.
I haven't heard any testimony that there was surprise that the closing letter appeared when it did.
That's it, other than the legal fee.
Well, just so you don't get off scot-free, Mr. Moulton, did you have any questions of Mr. Pastel?
I do not.
Okay, all right. I have absorbed all that. Why don't we do this? It is 5 minutes to 1. I'm happy to give you guys a little break, but I just as soon receive, if it's not going to be very lengthy, the attorney's fees information so that we can wrap for the day. And then I can take under advisement the motion for directed verdict that I've deferred a ruling on. And if I choose to deny it, I will have all the evidence I need to then enter a ruling on the merits. But I don't know what everyone else's schedule is.
Can I make a suggestion? What if I don't think I'm going to want to cross-examine Mr. Pastel about his attorney's fees bill. I don't know if
you're willing to cross that way, I'm fine. I mean, you know,
if we just submit affidavits, also it will give me a chance to add today to mine, and mine doesn't include that. And just, the bills are what they are.
Your rates are reasonable. And as long as I have not fly-specced the bills, and so why don't you exchange them if you haven't already once you top it off for today? Then if you have a concern based on what you received that you can't resolve, let's loop each other in, and maybe we can just do it over Zoom rather than dragging you in here. But ideally, the affidavits will be what they are, and there's no contest, and that's a great idea.
Then I would like to be heard to kind of summarize this before we leave today. I would try to keep it. I think we've hit the high points, but there are a few things I haven't had a chance to say.
So you want a couple minutes just to refresh and then do that, or are you ready to go?
I'm ready now. I don't know.
I wouldn't mind like the same 5 minutes.
Okay. Yeah, I'll be back out in about 5 minutes, and then you can each have about 10 minutes to summarize what you think we went through today and where we ought to go. Okay?
Thank you.
Thanks.
thank you for your idea. I appreciate that.
Well, and we're gonna, 1 o'clock now. I know he wants to leave by 2, so.
Yeah.
Well, point of order.
And remain seated. Thank you. All right, Mr. Pastel, did you take care of what you needed to take care of?
Yes, I did. Thank you.
All right, excellent. Mr. Moulton, I'm gonna have you go first. You can have last word as well if there's something Mr. Pastel says that you absolutely positively have to jump up and down about. But why don't you let me know what you think we've learned today and what ought to happen, please?
Judge, first on the voluntary payment issue, because that's sort of a threshold thing. That 13-111 specifically says that the payment is deemed voluntary unless it was made under an urgent and immediate necessity, therefore, or to release personal property from detention. He's releasing his property from detention. His house was effectively detained. He couldn't lease it. He couldn't sell it without paying them. Yes, there may have been some way that he could sell it and go through some machination to avoid having the argument that we're having right now, but it doesn't change what the statute says. And it was not intended clearly as a surrender of his rights here. He just felt like it had been months. I mean, it had been August of now, it was 17 months that the property's just lying dormant, and he had been through the process with Your Honor, and I respect your order, but he just wasn't able to come up with the money to go through that, and he felt kind of trapped, and the only way out was to sell the property. The other defense, so to speak, that Greystone makes is what I think he refers to as the business judgment rule, which I think applies in a corporate law a little differently. But here he's saying that as long as the association members meet and agree to do something, and it's not arbitrary and capricious, that it's so allowed.
So on that one, when we were together in courtroom 1D for your motion for the injunction, Greystone's counsel at the time didn't have the immediate benefit of having Ms. Harper around. And so when I ruled what I ruled, the defendant had not been able to point to any other instance of this type of treatment. And so it was easier for me to feel like this was made up out of whole cloth. Here we go. And to Mr. Pastel's, he's made 2 points at least about this. One is it's happened before. We didn't know that before. But 2, it's not a random number. They didn't say we're going to fine you $2,000 and 1 penny. Where'd that come from? It in fact was the rent. Now, I've got some questions as to how they knew the rent, what the rent was when they say certain things didn't happen, but that doesn't affect the overall issue of how arbitrary is it. So my question for you is, why is it arbitrary to say, you know what, you benefited in the form of rent, and if we don't claw all that back, you may still benefit to a degree, and we don't know how much you benefit. If you've got a mortgage, you're not benefiting every dollar of the rent. Turns out for Mr. Clarke, he was, most of the rent that was paid was income for him as opposed to covering, or profit, if you will, for him, because his expenses would have been low. There was no mortgage. But setting that aside, there's a certain logic to, for the fine to be a deterrent, it ought to be the rent. Because if it's $25 a day and it ends up being only $750 and your rent, I mean, you all went around and around with the math, and you make a good point that, well, you lost out on $750, but there is a certain elegance in the simplicity of saying your fine is your rent.
Well, I don't know that it's necessarily arbitrary. I do think it becomes arbitrary when you put that fine out there, and then when you have a meeting, the board is free to just say, well, we'll make the fine this, and it's really not then a set fine. It's whatever mood the board is in, and depending on the person that they're dealing with and whether we comply with whatever other hurdles they want us to jump, we're going to change the fine. That's when I think it becomes arbitrary and capricious. But beyond that, and it's also supposed to be reasonable. And I do not think that in a situation like Mr. Clarke's, where he had no idea of this restriction, that's his fault. But to then say 10 months into a lease, you now owe us every dime that you rented the property for, strikes me as just unreasonable to accomplish the goal of deterrence. But beyond that, you have the covenants in the record, and this is actually from the bylaws.
Thank you.
This is page 12 of 45 from the bylaws, and it helpfully tells you how to find somebody. And this is not changed by the leasing provision. But what it says is, for purposes of this case, is that you have to send a demand, and you have to give the person 10 days to cure. And then you can start fining them. And what they did in this case is they sent a letter on May 22nd, and it's not very specific. It says, we think you're violating a leasing provision. But if you count that as the first notice of this, there's a subsequent letter, I think it's June the 8th in the record, that says this is your formal notice you're being fined, which it's only 2 weeks later, but it may be significant for something here. They can't fine retroactively. I mean, the whole thing is premised on a violation of the bylaws to start with. They have to tell Mr. Clarke, you are violating the leasing provision. You need to do something about it, and you got 10 days. And in fact, he filed an eviction. It wasn't because of this. It was because the tenant wasn't paying, but he filed the eviction on June the 4th, about 12 days later. So they simply lack the authority to retroactively fine him for months that have gone by. And he did not collect any rent after April. He didn't collect May or June. And so it's unclear to me whether they fine you based on rent collected or based on rent contractually obligated to be paid. But this seems to me to be an act that is outside of what's allowed by the covenants.
For the lease.
For the lease.
Not for the tree. Based on your reasoning, then the tree would run from whenever he got notice that the tree is an issue.
The tree is specifically stated in Mr. Pastel's letter and on the Exhibit 16 ledger. The fine started April 27th, 2020.
Okay, but that was long after notice and what you need, explanation of what needs to be done to cure.
I think, yes, I think the part of the purpose of Mr. Pastel's letter, the exhibit number, I can't recall, was to set up the fines will now begin. Because the tree had been like that for months.
Well, I've now learned that, right?
Yeah,
Okay.
So on the tree, well, let me just make sure of, on the tree, you know, I mean, I'm not sure that there's enough here that is a violation of the covenants. To simply say, we don't like the way that tree looks, well, you know, it's an unkempt, first of all, they told him to start with, to trim the tree. So he did, to the point where they didn't like it. And then they said, you got to take the dead tree down. Well, the tree is demonstrably not dead. There's 2 pictures in the record of a tree growing. And I understand that it's somewhat comical the way it looked. But I mean, if they want to enforce these covenants and the covenants say you can't have a dead tree, well, it's not a dead tree. So also the ledger 16, they're fining him from April 27th to I think late September. The tree came down June the 6th. Well, they say, well, you didn't send the stump grinding bill or something like that, but it's there for all to see. And we did inform them. They were informed that the tree had been taken down. They still didn't adjust the ledger, and they didn't adjust the payoff in January. I mean, it's to say that they can just send whatever they think is right to the closing lawyer and just ignore reality. That just doesn't strike me as being a just way for this court to put some kind of stamp of approval on that. I think that pretty much covers that. As far as the attorney's fees go, we're under 13, I believe it's 13,611. That the attorney's fees are here allowed because the defendant's been stubbornly litigious and has put Mr. Clarke to unreasonable expense. You've heard all about what went on before the lawyers got involved. I don't think it's credible that they were offered a $3,000 to $4,000 buyout. You don't have my affidavit yet, but when you get it, you'll see that they paid me a $3,000 retainer. It would have made 0 cents at all. And if Mr. Clarke's anything, he's not that silly. That offer was never communicated. It was 15.5 or go away. And he thought that was unreasonable, and they would not budge off of that. You've got correspondence after that, through 2 or 3 letters, emails after that, in which it is insisted that the leasing fine be paid. And nowhere does it say, and I made a monetary offer. There's no response to that in the record of this lowered offer that would have resolved this. If I'm right, and they do not have the right to fine him retroactively, and they're insisting that he pay what is therefore an illegal fine, and doing that to the point that he cannot utilize his property, I think that's in bad faith. I think that's stubbornly litigious and putting him to unreasonable expenses. And I would ask that you award Mr. Clarke his attorney's fees. And I don't know what choice he had when he walked in my office either, but to file this. If you put yourself in his position, he either pays his fine, he can't lease it, he can't sell it. What can he do but incur legal expense? And I think that the fees that were charged were reasonable. You have to decide that. I would also point out that you have the discretion on attorney's fees under any theory to determine what's reasonable. and whether the issues in this case warranted what was spent, because he's already paid Mr. Pastel's firm, what, $10,000 roughly? I think it was 15 and 4 is 19, so now about $7,000. But that's Dale versus HGI Realty Inc., 254 Georgia Appeals 181. Whatever you determine on what are reasonable fees are only reviewable for abuse of discretion. My client's damages, of course, you have the $26,379.90. 7,000 of that is attorney's fees. 15,000 is what I believe to be an illegal fine, and the rest is the tree stump issue, which you've heard all about. We believe we've proven that he lost rent for 17 months from August of 2019 to December of 2020, that the reasonable rent for the property was $1,595 a month, and that is $27,115. And as we talked about earlier, even if you think that the payment made at the closing was voluntary and more or less acted as a forfeiture of all of his arguments, if the covenants were breached by the association, and if that breach resulted in his failure to be able to rent the property, he still has that claim for lost rent. And then, of course, our attorney.
All right.
Thank you, Judge.
Thank you, sir. Mr. Pastel.
Good morning, good afternoon, Your Honor.
Good afternoon.
Been a pleasure as always. Let's talk first about working with Mr. Clarke. We've heard conflicting testimonies about it, but, we heard from our client that we were trying to work with him, that we were willing to reduce the fines, and then they get back, why only want to pay $1,000? So my client gets upset about that. I think they're upset because they don't want to pay any fines really, or just $1,000. And as both parties testified, really after that point, nothing more happened. That was the end of it, so to speak, as far as the thing. I did hear an argument today, though, that because we're willing to work with them, that means the fines were arbitrary and capricious because we can lower them. That talk about being boxed in or playing a catch-22 on somebody, right? That certainly is it. If you set this as the fine, the amount of the rent, but boy, if you try to work, he comes to you and you work with him on maybe reducing it, and he supplies you other information. Well, now that's an arbitrary fine because you're willing to reduce it. That's not a good argument at all, Your Honor. Detention of the property. Your Honor had just issued an order saying that he could rent the property, right? And I hate to go back to my mortgage and HELOC example, but I think I need to now with what we heard, because what he's saying now is that he didn't have the $5,000 to rent the property to put in the court registry. Well, yeah, he had plenty of equity in the property he could have gotten. He could have gotten a small HELOC loan, paid the $5,000 in the court registry, and moved on. I'll just give this example on the voluntary payment doctrine, right? You get a water bill, you think it's got some collateral charges on it you don't owe. In fact, actually, I can get you this case. I forgot, this is an actual class action case where they didn't like the extra fines and fees being added on to some sort of utility bill or something, right? All the clients went ahead and paid it, but they argued as a class action that it was improper. And I think it may have even been against the statute. I don't necessarily recall. I don't want to stretch it too far. Let's just say it's, was a breach of their agreement, right? And the court said, yeah, but you paid him. Okay, and I'll be sure to send you that case. Now that refresh my case. And I want to clear up something about the leasing fine.
The what?
The leasing fine, about fines in general, right? Because I noticed a little misconception, I think, in the TRO and some comments this morning. Fines are a penalty. No ifs, buts, or what's about it. They are a penalty. That is what a fine, you look it up in a dictionary, you're supposed to be, right? They're not illegal because they're a penalty. That's what they're supposed to do, to penalize, in part, to penalize the person for what they're doing. So when you say, yeah, but you can't have a fine be so large that it's a penalty, well, no, right? It's supposed to be a penalty, right? The Winslow at Eagles Landing case is unique. I come across that case often. What was in the declaration was a simple statement that said, you can fine in accordance with the declaration. Okay? And that was it. Nowhere else in the declaration did it ever say you could fine, or the procedure for fining, anything, nothing. So while you could fine in accordance with the declaration didn't have anything to fine, right? That's what that case stands for, okay? And we don't have that situation here. And in fact, if we want to get technical on this thing, going back to the 10-day notice, right? The 10-day notice was sent May 22nd. He didn't get the eviction to get the guy out of there until July 19th. That's way more than 10 days. Right? It doesn't matter when he filed the eviction, it's when he got the problem abated. So I don't really want to get hung up on technicalities necessarily with that thing. The board of directors is definitely given the authority under the governing documents to make sure people's properties are kept in the community standard. Right? That's what we call, and I'm sure you've heard it in other cases, the drive-through. A property manager does a drive-through and cite people for weeds in the yards and things like that. Right? The community standard is, set by the board. As long as you got two equal properties and you don't find them both, yeah, that's a defense, right? But it's not a defense to say, well, I don't think I didn't have that many weeds, right? Right. That's, unless you show a picture and your owner laughs at it, I agree, you got a beautiful yard, but that's not what's going on here. We clearly got a tree stump, right? And so it's now they're trying to argue, well, no, that is not a community standard here. And I do want to clarify, there was no testimony that we received any knowledge that the stump had been removed, right, until right around closing when we went and looked. And then we did it for the ring around. But he never testified that he gave it to us.
At the hearing we had on the motion for injunction, it was made clear that the stump had been removed.
Okay, when the fines were stopped, I mean, they did stop by that time.
Okay.
So, okay. All right, so maybe I'm wrong, maybe at the hearing. That's
no later than that, maybe before, and the fines had stopped. I agree, but it's not that folks learned at the closing.
Sure. Okay, no, and you're right. That's my bad for not having attended the TRO, but that's still after the date of the stopping of the fines on here. As far as my attorney's fees go, and this is why I brought up the fact that, fines are assessments, right? We're entitled to attorney's fees under the CCRs. Not 13, I could argue 13,611. I don't think either one of us get them for 13,611. But we have them under Article 4 of the Declaration for collection of assessments, or fines, in other words. So the first half of this case, until the selling of the home, we were trying to collect those things. The second half of the case, I'm trying to preserve them under our CCRs. Okay, so I'll get you that one case.
All right, not so fast. Walk me through why you think Section 20 of Article 3 doesn't do what Mr. Moulton says it does, which is fines don't properly start accruing until after notice is given, which makes sense. You drive by and you notice that the tree now looks more like a trunk or a stump, and that bothers you as the member of the board, but you don't do anything about it. And time passes, and you drive by again a few months later, you notice, gosh, it still looks bad. And then finally, 6 months later, it continues to look bad. Here's your notice. He doesn't fix it, and you tackle on the 6 months that you've been aware that it was that way. Section 20 seems to suggest that would be an improper fine, but I'll note that I don't know that's all of Section 20. I just have one page, so there may be additional language. But if Mr. Moulton and I are interpreting Section 20 correctly, wouldn't the remedy for the POA be any rent that Mr. Clarke earned after they said, wait a minute, there's a problem here, you need to stop, and he didn't stop, which of course he did. He got the guy evicted. And so maybe the rent that was collected, of which there was none, because that's why he was evicting the person.
Right.
So how is it appropriate to say all that rent you earned for the months of the lease when the guy was there? And I'm assuming, I think everyone acknowledges that it was not a good lease, that lease was not compliant with many, if any, of the requirements set forth in the declaration, the bylaws, et cetera. Ignorance is not a defense, but the fining procedure seems to suggest they should be prospective for ongoing violations.
Well, I'll put it this way to you. You'll interpret this right. It's that your fine, right? So your fine has to be going, hold on, I want to make sure I say this correctly.
Well, let me ask it a different way. Let's say the patrol goes by and they notice white rocks around the mailbox. Do you believe that the bylaws, the declaration, et cetera, would empower the board to assess a fine then and there, like writing a ticket, putting it in the mailbox, you now owe $100? Or in fact, is the language here, you need to explain the alleged violation, white rocks, that's not consistent with community standards. Here's what you need to do to abate it. And we're going to give you, it has to be more than 10 days, or at least 10 days. We'll give you 2 weeks to get the white rocks out of there. If the white rock violator got the white rocks out in 8 days, no fine would be appropriate. Yes or no?
Yes, no, I agree with you.
Okay.
I agree with you. And
so how are the rent fines appropriate here? Not dollar-wise. You've been convincing today, and Ms. Harper helped educate me, the reasoning behind the size of the fine. It's the chronology.
and to maybe rephrase it, at least in a little bit of light to us, is that should Mr. Clarke be able to enjoy the windfall of keeping the tenant under the radar screen for 10 months?
I understand that perspective.
No, I get it.
That's
Right.
It's like if you just put the white rocks out when the people were not policing the neighborhood,
Right.
and then he would hide them when they were driving by.
I get it. Hey, other. Okay. So, other than the unfairness of what's going on, I mean, white rocks, tree stump, that's why I'm not really arguing as June 6th is when he took it out, because it is open inventories.
Sure.
But
this was clandestine.
right, that's always my problem with Airbnb and rentals and situations like that we're constantly dealing with in these sort of situations. And so that's really, what the argument is that to allow it otherwise, allows that activity to be clandestine, if you don't permit such.
Okay.
Right.
Got it.
But again, we're not talking, I also want to make sure that we use clear words here. Let's assume you're right, and you take it and you say, okay, the leasing amendment says only a $250 fine. You know what I mean, for your initial cut, and then something daily, that amount, right? Charging more, it's not an illegal fine. It may be an improper fine, but making it illegal, I think they're trying to circumvent that voluntary payment statute by putting more punitive words on what the board may have done.
Okay, and you don't need to spend, I feel better educated now about the basis for the monthly fine. I'm just working through the chronology of events. So you'll send a case. You both will share with each other affidavits about legal fees. If there are no issues, or those issues that arise can be resolved between the two of you, then get those to Ms. Niles, and we'll make them part of the record. Mr. Moulton, did you have anything you wanted to say in rebuttal?
Just on the last point there, the leasing amendment says that the association may fine the owner an initial fine of $250 plus additional daily fines for continued violations of these provisions. So it's all looking forward. And Mr. Clarke didn't violate the leasing provision after he got the letter. I mean, he was actively working to cure the problem. It just couldn't be cured in 10 days, but he didn't take any money.
Okay.
Do you want that within a period of time, a week, or do you?
I won't work on this until you get it in. So if you want to take 6 months, you can explain to your clients why you took 6 months.
Well,
So I'm not setting
the
deadlines.
money, so why don't we say 2 weeks?
Okay, great.
Thank you, Judge.
Thank you, everyone.
Not gonna hold up the works.
Mr. Clarke and Ms. Clarke, thank you for being here. Good luck with everything. I'm glad that in some ways you've been liberated from this situation, and hopefully you can head in a different direction. Mr. Pastel, you should have let Ms. Sharp say a little bit more than she got to say. I guess she got to observe a trial. Maybe next time she can ask a witness a question. State your name for the record.
I'm more of a transactional attorney.
Well, it's good to see what happens in case, they're short one day and they say, hey, get in here, you need to do this.
Exactly.
All right, Mr. Moulton, appreciate it. All right, take care, everyone.
They lock the doors. Right, good afternoon.
Take care, everyone. Thanks.